We are now being recorded.
Okay. Good afternoon and welcome to the Board of Trustees meeting of the State Bar. As a reminder, as you just heard, this meeting is being recorded. May we have the roll call, please?
Broughton,
Present.
Chen, not present. Cisneros,
Here.
Dela Cruz, not present. Duran,
Here.
Knoll, not present. Stalag, not present. Shelby,
Present.
Sowell,
Present.
Stallings,
Present.
Tony.
Present.
You have a quorum.
Thank you, Madam Secretary. Good afternoon, trustees. Thank you for your attendance and for your work at the committee meetings earlier this morning. We're going to move on to the portion of the agenda for public comment. This is the call for public comment. Staff, State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those of you who are participating by Zoom, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the board, please click on that hand icon now, and State Bar staff will call you in the order that the hands are raised. I have noted that there are a handful of folks already who have raised their hands. If you are participating by phone, you may virtually raise your hand by pressing *9. Again, doing so will alert State Bar staff that you would like to make a comment, and staff will call on you and open your microphone so that you can address the board. Due to our limited time, we are going to limit each individual speaker to no more than 3 minutes. Please note that we will have on screen a counter visible to all the attendees during the duration of your public comment. The timer's 3-minute countdown will begin as soon as you start your comment, and you will be verbally alerted once you have 30 seconds remaining in that time allotment. The on-screen timer will flash throughout the final 10 seconds. Okay, with those ground rules set, if we could recognize the first person, who is Benjamin Cohn. Good afternoon, Mr. Cohn. Welcome, and thank you for joining us.
Thank you. I'm commenting again in follow-up to the hearing for those who weren't there about the rules revision proposal for the testing accommodations. I understand that you're being asked to circulate for public comment, and it may seem innocuous, but because the admission rules are very discriminatory to people with disabilities, and when positive reforms start will affect which exam cycles thousands of applicants will have access to, I'd urge you not to spend more time waiting for public comment on a proposal that is making those procedures even more discriminatory instead of actually improving those aspects of the procedures, and to instead start fixing the procedures before going through the process anymore. The things that is the most important to fix is the timeline for staff response to a given iteration of argument and evidence from a disabled applicant. Most testing entities can do this within 10 days. The State Bar staff previously had a guidelines of when they deem it complete, they'll do it within, they'll try to do it within 60 days. That often in practice denied an applicant their ability to appeal. Now they want to just say it will be within the order received. And if you don't do it several months early, impossible for immediate repeaters, you may not even get a decision in time for the next exam cycle. That's an initial decision, not a decision on appeal in time for the next exam cycle. Also, of very significant importance is the appeal changes. Already, the process does go out to expert consultants. This formalizes it more, yes, but at the cost of CBE review, which is the only form of panel review. The State Bar staff now would have the final decision be made by the Director of Admissions. And although they say that the cap that's new, that had been rejected before, that they reintroduced of 1 per exam cycle is per exam cycle, they've left that vague so that it could be interpreted as once lifetime for the applicant, which is a huge deal. If applicants can't necessarily appeal denials on future exams lifelong, their sole recourse is discretionary review to the Supreme Court. The procedures also impose problematic restrictions on the admissibility or
I'm sorry, your time is up.
of evidence. Okay, thank you.
Would help if I got myself off of mute. Sorry about that. Mr. Cohn, thank you for your comments and appreciate you attending the public hearing a couple of weeks ago. Actually, less than that. Next, we have Paul Kramer. Paul, good morning. Mr. Kramer. Good afternoon.
Good afternoon. I chair the Committee of Bar Examiners, but today I want to be clear I'm speaking as an individual. And I was also a member of the PLP working group. I agree that the pathway program should be extended for those who did not receive notice, but with a 2024 rather than 2025 sunset date. That would provide sufficient time for those people to complete the requirements and be licensed. The original PLP program addressed the pandemic's effects on the summer 2020 bar exam and a desire of some to avoid taking the exam under pandemic conditions without delaying the start of their legal careers. The pandemic has abated and 4 bar exams have been given since 2020. With its original mission fulfilled, the PLP should sunset as scheduled. The staff analysis, however, summarily dismisses that option as unworthy of discussion. Extending the PLP for 3 more years, doubling its length, to allow those participants who have not yet passed the bar exam to continue to practice under supervision until alternative pathways may become available is unfair to past and future graduating classes that are not numbered 2020. My comment to that effect is reported to you, but is not addressed in the analysis. The Blue Ribbon Commission has been working through these issues for a year now. That the BRC appears deadlocked regarding an alternative pathway is not licensed to make an end run, especially with limited information and little time for careful consideration or public input. Trying to edit my comments to an expected 2-minute limit reminded me how short and stifling that limit is. Specifying a minimum comment of period of 2 hours leaves room to increase that to 3 minutes as you've done today. Reducing the lead time for written comments from 5 days to 24 hours makes them a more viable alternative, but people should not be forced into that lane in order to be heard. The policy should direct staff to forward comments as they arrive rather than waiting to provide them all as a group at the when the deadline passes. And they should also describe how the public may access those comments, which I think is difficult right now. With the extra minute, let me add, a 2-hour minimum public comment period is not going to work well for the CBE's examination subcommittee.
Seconds remaining.
When it meets solely to consider testing accommodation appeals in closed session or board subcommittees for that matter. The policy to me seems ambiguous about when and whether the 2 hours can be reduced. And finally, I don't mean my fairness observation as a recommendation to expand eligibility for the program. The admissions fund has too many functions that are not paying their way, and adding one more with so much uncertainty about implementation details and costs isn't prudent. Thank you.
Apologize, but your time has expired.
Thank you, Mr. Kramer. Next, we have Carolyn Shining.
Good afternoon, and thank you, members of the board, for letting me have a moment to speak. My name is Carolyn Shining. I'm speaking as a member of the public. I'm a former member of the Paraprofessional Working Group and one of the authors of its only a couple of dissents. I would like to point out a couple of things. And as the prior speaker mentioned, transparency is important. And if the presentation with regarding to the provisional licensing discusses a pilot program that would lead to a non-exam pathway, that is an improper use of public comment and public time. We just learned as a bar only a few days ago that this might be something that was presented. It has not been given any time for public comment, and any public comment that would be given is not going to have the benefit of the full vetting of all the stakeholders, including members of the bar. As someone who is on the paraprofessional committee, I well know the difficulty that there is in having a result that was not necessarily a positive one in terms of having an output that was really accepted by the stakeholders of California. And I know that controversy and the pain of having all that hard work be ended in that fashion. But we do have to celebrate those who passed the bar exam, those who are provisional licensees and who really made it through. Those should be celebrated and honored. And I fear that, again, the State Bar may be seen as not a promoter of excellence in legal services, but an apparent attempt to take all lawyers at their worst and failing to uphold the best. We should not be taking efforts and making efforts to water down our legal system. Comments that there is California exceptionalism are really not helpful with regard to being the best of the nation in terms of our presentation of legal training, of legal skills, and what it means to be a California lawyer. Again, we are all aware that there are people in California who are in need of legal services. That cannot be denied. I learned that through the paraprofessional program. But watering down programs without public comment, without taking consideration of the licensed stakeholders, the licensed practicing attorneys of California, and again, the Blue Ribbon Commission did engage in a lot of controversial issues and was given a lot of feedback by the practicing bar. I think it is time to celebrate our working licensed members for the high levels of exceptionalism, if we can use that. If we can use that term positively. Over 200,000 attorneys in California who give amazing service to their clients. I think that should be the effort that the Board of Trustee honors today, and any pilot program for a non-pathway should be extended, continued, or discussed and given full vetting in the future. Thank you.
Thank you, Ms. Shining. Appreciate you making those comments. I see that we've got about 21 or 20 people still with their hands raised. I suspect that similar to the folks we've heard from so far, people are interested in the PLL item on the board's agenda today. And I just want to emphasize that our task is to adopt a recommendation to submit to the Supreme Court regarding the extension of the program. The board is not being asked to make a final decision as to the future of the PLL program, nor do we have the authority to do so. Certainly, this is a forum where we welcome and encourage everyone to share their thoughts about the program. I just wanted to contextualize what we have on our agenda today. With that being said, let's move on to Chantel Johnson. Ms. Johnson, good afternoon, welcome.
Good afternoon. Thank you, Mr. Chair and trustee members. My comment is regarding agenda item 701, the recommendations to extend the original and expanded pathway program to include the pathway to licensure for the original PLPs and the supervised practice pilot program. As an original PLP and 2020 graduate, I've actually waited for a program like this because the profession and law school hasn't been very diverse, equitable, or inclusive in the past. And when the pandemic hit, we were all robbed of traditional rites of passage. But all the recommended options in the report indicate that they're only for remaining participants, implying an exclusion of original PLP graduates who never got to fully take advantage of the program. The State Bar indicates on October 3rd, surveys were sent to original PLPs, but to my knowledge, not to everyone, because I never received one through my portal or personally. For original PLPs that didn't apply and those that attempted to, but were rejected at no fault of their own because of misrepresented information by the State Bar and their acknowledged failure to properly notify all participants. Since there was no proper outreach, everything appears to be working against the original PLPs, who this program was originally designed for. Unlike pathway participants, there's no recommendation in the report to reopen the program for original PLPs to participate in the proposed extensions and the proposed pilot pathway to licensure. Therefore, I respectfully ask the Board of Trustees to include recommendations in the report to reopen the program for all original PLPs that never participated at all before submitting it to the Supreme Court, because I believe this is an opportunity to move diversity, equity, and inclusion forward. Thank you, trustee members, for the opportunity to comment.
Thank you, Ms. Johnson. Next, we have Jackie Gardina. Once your microphone is activated, you'll have up to 3 minutes to address the board. Thank you for joining us.
Good afternoon. I'm Jackie Gardina, Dean of the Colleges of Law, and I've had the privilege to serve on both the California Attorney Practice Analysis Working Group and the Blue Ribbon Commission on the Future of the California Bar Exam. I'm here to speak in support of Agenda Item 701, though I want to use my time to speak specifically in support of Option 3. I am transparent about my support for an alternative pathway to licensure, in part because I do not believe a standardized exam can measure who will be a skilled, competent, and ethical attorney, although it's very good at identifying who's competent at taking standardized exams. My belief was only strengthened after I served on CAPA. One striking finding of the CAPA report, and one that has influenced my thinking about a supervised practice pathway, is the survey results related to public protection. The survey had attorneys identify whether a particular task could harm the client, a measure called criticality. Most new attorneys, all who had successfully passed the bar exam, did not recognize potential harm. It wasn't until year 4 of practice that the potential harm was readily identifiable by the attorney. The BRC has struggled with the question of whether to recommend a supervised pathway to licensure, in part because there's a lack of empirical evidence to support its efficacy in measuring competence. Although we have heard from other countries such as Canada and other states such as New Hampshire, Wisconsin, and now Oregon that have developed alternative pathways, we do not have data specific to California and its unique legal landscape. The State Bar staff's Option 3 proposal would allow California to develop the necessary data missing from the BRC's deliberations, specifically a reliable measure of competence. This would allow the Board of Trustees and the Supreme Court to make a more informed decision about an alternative pathway with the benefit of data specific to California. It will also allow the State Bar to ask the question whether the public is better protected by a score on a standardized exam or by new attorneys learning in a supervised setting. I appreciate the time you've given me today.
Thank you, Ms. Gardina. Next, we have Tyler G. Welcome, and you've got 3 minutes once your microphone is activated.
I would like to take the opportunity to thank the board for their hard work over the years, particularly in the face of growing pressure from attorneys, applicants for admission to practice, and the public at large. I have worked in family law since March of 2018. I'm a provisionally licensed lawyer and have been since February of 2021. Like many provisionally licensed lawyers, I took the opportunity in lieu of taking the bar exam in 2021 because I needed to enter the workforce right away in order to provide for my growing family. I am a disabled veteran, a non-traditional and first-generation law student, a father to differently abled children, and someone who cares deeply for their clients. The PLP has been an absolute blessing. Never before have recent graduates who have not yet taken and passed the bar exam been given the opportunity to represent clients within the full scope of their practice areas. I have completed a full dissolution trial and successfully represented dozens of clients over the last 2 years who may have not had access to the largest firm in my county where I worked. And even now at my current firm, I am at a reduced rate, allowing cost-conscious clients access to representation. That said, I did not pass the July 2022 bar exam. During this year, I caught COVID-19 and my youngest son, Atticus, was diagnosed with moderate autism. Of course, I immediately sidelined my studies in order to find him resources and get him enrolled in the San Andreas Regional Center. I understand that the way that I manage my time and my life and my work are my responsibility alone. But at the same time, my life looks much the way that it does because I care about my family, I care about my clients, and I care about my community, and I am passionate about family law. I am trying to do everything that I can to provide for my family, to be the attorney my clients deserve, to be the associate the partners of my firm can rely on, and to meet the demands of the bar exam, and I am coming up short. Now, I'm prepared to take the California bar exam on February 21st, 2023, even though doing so will create a hardship for my family, and I will miss the birth of my third son on February 21st, 2023. However, my family is here now, and my clients are here now and in crisis, and my family cannot afford for me to lose my provisional license
You have 30
between
seconds.
now and May, and when results are posted, and my clients cannot afford to lose the attorney. To that point, the California Rules of Professional Conduct allow for an attorney to become competent in order to represent a client through the association with experienced attorneys and by studying, prior to providing that representation. And if I have done that for the last 2 years, in my understanding, I should be able to be seen as being minimally competent. If the board would allow me just—
I'm sorry, Tyler. I'm gonna have to stop you there. The 3
Apologize.
minutes lapsed a little bit ago. Certainly appreciate you addressing the full board of trustees. You were kind enough to join us at the public hearing on the state law's various programs, and so we appreciate you taking the time to let the full board know your experience and your concerns. Before we move to Deborah Merritt, I want to remind the members of the Board of Trustees and to let the public know that the board has received dozens of written comments on the PLL issue as well as other issues. Those have been transmitted to the board in writing for their review. We have looked at those things very carefully and closely, I believe, and we will add it to what we're hearing today as we proceed through our agenda. So thank you all for taking the time to contact us. Deborah, you've got 3 minutes, Ms. Merritt, once we activate your microphone. Good afternoon and welcome.
Thank you. I am Deborah Merritt, the John Deaver Drinko Chair in Law Emerita at The Ohio State University. I will also address the proposal to extend the provisional licensure programs. I'm an expert on attorney licensing issues who has worked with NCBE in several states in that capacity. I recently assisted the California State Bar pro bono in designing the PLP survey, although I had no involvement in drafting the staff's recommendations based on that survey. Indeed, I did not see the recommendations until they were posted publicly. But having seen those recommendations, I strongly support extension of both provisional licensure programs, and in particular, extension of the original PLP to create a pilot program using supervised practice as a pathway to licensure. I helped Oregon develop a pilot like that earlier this year. We were able to create a program that is fair, reliable, and valid for measuring minimum competence to practice law. That program requires provisionally licensed lawyers to submit documents and other work product that bar examiners assess for minimum competence. The program thus measures competence far more comprehensively than any written exam can do. California has a chance to build upon and greatly improve that work by developing its own pilot program. The State Bar's PLP survey suggests that a pilot would be quite successful in expanding client service and diversifying the profession. 92% of PLP supervisors were satisfied with the work of provisional licensees. They also noted that provisional licensees were particularly hardworking, that the licensees allowed their organizations to serve more clients, and that the licensees added diversity to their practices. State Bar statistics confirmed that provisional licensees were more racially diverse than other newly admitted attorneys in California. I urge California to build on this success and collect more data by expanding the original PLP to create a pilot program allowing licensure through supervised practice. Thank you for giving me the time to speak to you.
Thank you, Ms. Merritt, and thank you for your assistance over the course of this very important issue. Next, we have, I'm sorry if it's Rian or Rayan Pacheco. Ms. Pacheco, welcome, and you've got 3 minutes. You'll need to unmute your phone.
Hello.
There.
Hi,
Hello.
my name is Rianne Pacheco. I'm speaking for the Legal Aid Association of California. We have been following the PLL program, both the original and the pathway components, since their creation. We hear consistently from our community that PLLs have increased the capacity of legal aid organizations to serve clients who are in a legal crisis. We have also heard from many of our members that very competent and effective PLLs have been unable to pass the bar exam yet, largely because of the difficulty of studying for an exam while also fully employed at a legal aid organization. Option 2, for that reason, might not be the best solution for many PLLs. We also know that many may have financial reasons for not meeting all requirements, like paying for the moral character determination, when an employer will not cover the cost. We understand that option 3 through 5 may provide more flexibility, but we have not had enough time since the posting of the memo to gather full community input on all options proposed. We support giving PLLs more time to take the bar exam at a minimum as a reasonable extension, and our community supports the extension of the sunset as articulated in options 1 and 2. I can also say that our community has expressed support for exploring an alternative pathway to licensure before the Blue Ribbon Commission. Our community continues to struggle to recruit attorneys, and alternative pathways may be one of the solutions. As to the actual program design, if approved by the Supreme Court, it should include representatives from legal aid and access to justice communities. And I would just like to add that alternative pathway to licensure is not an easier route, just a more equitable one. Thank you.
Thank you, Ms. Pacheco. Next, we have NC. NC, welcome. You've got 3 minutes once your microphone is activated.
Thank you. And thank you to ladies and gentlemen of the board. I would like to tell you why I went to law school. I used to be an executive chef. I participated in a program called Chef for Kids, where we donated our time to prepare meals for schools in lower socioeconomic neighborhoods. One morning, I was out of school and I was eating grapes, and a 5-year-old came up to me and asked, "What are those?" You can imagine my confusion, because who hasn't seen grapes before? He then said, "Those." I said, "These, they're grapes. Would you like some?" He said, "Yes, I've never seen those before. We don't have those at home." As his teacher scurried him away from me, she could see the look on my face and asked if he'd been bothering me, and I assured her he hadn't, but I was bothered because that just didn't make sense to me. What she shared with me rocked me to my core next. This young man was living with his grandmother, who was terminally ill. Some few months before, his mother had been violently and brutally gunned down in the parking lot of his 2 younger siblings' preschool by her husband. She had tried to no avail for 2 months before she was murdered to get a restraining order against him. And she was unsuccessful because she was being turned away for document errors and she could not afford an attorney. I went home that day and applied to law school because I wanted to make a difference and I wanted to help people. I vowed that if I could just help one person, one mother, one child, I could truly make a difference. And that is my client base today as a provisionally licensed attorney. I work for free. I work for discounted fees. I'm not in this for the money. I now find myself staring down and looking at the same figurative ledge that sometimes I have to pull my clients back from. My request to the bar is whatever your recommendation to the state Supreme Court is that we tweak the MPRE requirement. There are those of us who have not taken the MPRE, and to now make that a requirement to continue in the program when it hasn't been before, and before the next MPRE exam without giving us an opportunity to take it would be a detriment, both to me, financially and personally in my life, and also to my clients. That takes me away from the people that need me the most and that I am able to help the most because they can afford my services, or I donate my time and my services to these people. So I do ask that whatever recommendation the bar makes, they take that into consideration in doing so. Thank you, and I yield my mic.
Thank you, NC. Next, we have Ray Hayden.
Took me 3 shots to hit the unmute. Hello, Ray Hayden here, and I hope everyone can hear me just fine and not too loud. With the onset of the pandemic, the California Supreme Court and California Bar staff put together the Provisionally Licensed Lawyer Program. In an accidental but very beneficial manner, the PLL program has become the perfect beta test to demonstrate that such a program can not just meet, but exceed the purpose of the bar exam itself. The PLL program was tweaked by California Bar staff with California Supreme Court oversight into a viable program which can and should become an alternative pathway to the admission to the California Bar. Participants in the program have been demonstrating their ability to exceed minimum competence and the knowledge required to protect the public. While I had not personally qualified to participate in the program, I know a number of candidates who did qualify and participate with great success. My support is for what I consider to be option 3 of the California Bar staff recommendations for the current participants to become fully admitted attorneys without having to sit for the bar exam. Nothing really beats the actual practical experience in the field. I'm sure everyone would agree with that. And the PLL program has been providing participants that very thing. I further agree with the California Bar staff recommendation to use the PLL program as the pilot program in creating the non-exam pathway to admission. I'm very happy that I did not go first. I fully support all of the comments made by Dean Gardina and by Deborah Merritt, who's also worked with IALS, I-A-A-L-S. I'm sure you're all familiar with them. And I also am a non-traditional student. In fact, my master's degree was acquired while I was waiting for traditional ABA schools to make up their mind whether or not I could go there or not. And I have 30 years in litigation support. All of my clients are attorneys at the local, state of Florida, federal, and they also, the attorneys also work for located in other nations. I also worked for the local cities in Southeast Florida. I worked with the state of Florida, the federal government, different agencies within the federal government as well. Even attorneys out there in California, and I am located in Florida. One thing I want to mention that nobody's probably going to be able to bring up here, and it'll be just real quick. I'm a non-traditional student. I live in Florida. I'm an old man. Okay, it's highly unlikely that I'm going to move to California. But if I pass the California bar exam, I have to first. I can't get it anywhere else first. And in Florida, I have to either wait 10 years or take the LLM degree to be able to sit for the Florida bar
30
exam.
seconds remaining.
But I can practice immigration law in any jurisdiction, but I need to either pass or gain admission in another jurisdiction first. And because I'm a non-traditional student, I have to pass to California. I have to gain admission to California first. It's the only state available for the people who took what I call the California option. And I thank you for your time.
Thank you, Mr. Hayden. Next, we've got Todd Hill. Mr. Hill, welcome. Good afternoon.
Good afternoon. My subject, of course, is not the subject of the last 10 or so I will try to keep my statements brief. My issue for the board today stems from a long-standing issue. The State Bar of California is a monopoly regulator and market participant with the mandate of protecting the public, regardless of the state's or its agents' conflicts of interest. The People's College of Law, PCL, serves as a vertical and regulatory competitor because it's the regulated versus the regulator as a registered fixed facility law school and has been allowed to operate for years in violation of state and federal law by issuing, for example, 2 units instead of 3. The school has defrauded its students in the past. Consistent and clearly negligent student selection criteria are used by the school. In fact, in some years, in most years, between 80 and 90% of the students that it admits for first year do not pass the baby bar, even though they have a duty of careful selection. Then, in some cases, they've openly, and the bar is aware of this, admitted students who were not eligible to be admitted, including they did not meet the 60-unit minimum. A name in question here would be Maria Gonzalez. All students were recruited under fraudulent circumstances, as we were never told that we'd only be given 2 units. And consistently, though, the school does generate every 2 to 3 years between 1 to 2 folks who pass the baby bar. And it does generate attorneys, right? But really, the reality is that it's doing so because the fix is in, because you can't transfer once you pass the baby bar The horse is in the stable. It can't go anywhere. A restraint of trade that is facilitated under color of law by the bar because it allows the school, to its knowledge, to act unlawfully for years. The market restraint is twofold, and it is affected under the color of law, as I've said earlier. A student cannot transfer because bar policy does not allow institutions to grant more units than were offered by the school. So a student takes an immediate haircut as they've already been deprived of the benefit of the bargain of the deal. A student cannot retake what is essentially the same class again, or partial under state bar policy, and so cannot actually complete the requirements if they transfer. This prevents a pathway for graduation. Great, that's all I need. A student cannot obtain resolutions from other public agencies, since the California State Bar is the monopoly regulator. The monopoly regulator. And instead of acting in its regulatory capacity, it allows the school to continue not only its unlawful practice, but it allows it to negotiate with the student for resolution. The State Bar is operating in ultra-virus fashion, and it has committed violations of the Sherman Act.
I'm sorry, your time has expired.
That's all I need to thank you.
Thank you, Mr. Hill. Zach Newman is up next. Mr. Newman, you've got 3 minutes once your microphone is activated. Welcome.
Good afternoon, trustees. My name is Zach Newman. I'm the senior attorney at the Legal Aid Association of California. I will be giving very brief comment on item 708, the proposed amendments to state bar rules. I just want to note that we worked extensively with state bar staff and the Legal Services Trust Fund Commission working group on these proposed revisions. We solicited input from our community and submitted both written and oral comments at every step of the way. A LAC staff person, usually both myself and our executive director, attended every meeting of the Rules Revision Working Group over the last several years. And so as a result, we urge the Board of Trustees to support these recommended changes. Thank you.
Thank you, Mr. Newman. Claire Solat, welcome. Good afternoon.
Good afternoon. My name is Claire Solat, and I am the co-founder of the Legal Service Funders Network, known as the LSFN. In 2020, in response to the COVID pandemic, we created the LSFN Public Interest Bar Fellowship. We place new law school graduates in legal service organizations where they hone their legal skills as they prepare for the bar exam and await their results. Over 80% of our fellows come from non-traditional backgrounds, and over 80% of our alumni continue in positions where they help to increase access to justice. The results of our evaluations align with the State Bar survey, in that over 95% of our fellows felt they were well supervised, close to 100% of our LSO hosts felt their fellows increased capacity, and almost 90% would consider hiring law school graduates who pursue an alternative pathway to licensure. The LSFN partnered with LAC to administer a survey to the state's over 100 legal service organizations with regards to their upcoming hiring needs. More than 3/4 anticipate needing to hire 1 to 5 new entry-level staff attorneys, and 3% expect to hire more than 6 each year. However, as noted before, it is extremely difficult to hire new staff attorneys, as the pool of individuals who choose to work in the public sector is small, and many who are passionate about the work find it difficult to pass the bar exam as they come from non-traditional backgrounds and have less financial support than their peers. As nonprofit leaders, you all know the dire need for assistance for low-income folks in California. This is an excellent opportunity to increase access to justice and diversity in the profession. The PLL program has been a huge plus for the public sector. PLLs are extremely diverse, and 15% of PLLs work at legal aid organizations in comparison to the less than 1% of the entire California bar who chooses to do so. Over 100 of the current PLLs are helping to meet the needs of moderate income clients in rural and suburban areas. The State Bar's report concludes that PLLs have not put the public at risk. In fact, the complaint rate for PLLs is lower than their peers. For the reasons above, we strongly support the State Bar staff's recommendation to extend the PLL program until December of 2025 and to use this opportunity to pilot an alternative pathway to licensure. Finally, I'd like to share with you that several funders from the
You
LSFN
have
are,
30 seconds remaining.
thank you, in helping to fund a pathway program. These funders are committed to increasing access to justice and diversity in the profession, and therefore the concerns mentioned earlier with regards to cost should not be a deciding factor from this group. Thank you again for your time.
Thank you, Ms. Solot, for joining us again. Next, we have Susan Bakshian. Ms. Bakshian, you'll have 3 minutes once your microphone is activated. Welcome.
Thank you. My name is Susan Bakshian. I currently serve on the Blue Ribbon Commission, but I speak today as an active member of the California State Bar. I support the State Bar recommendations on the PLL program, especially those options that provide an alternative to the bar examination. The Blue Ribbon Commission has passed resolutions to recommend changes to the bar exam and address its faults, but this is not enough. It's naive to believe that the current exam can be repaired into something that needs no parallel alternative. Remaining wedded exclusively to an exam does nothing to address diversity, nothing to address the high costs of bar prep and going without income to prepare for the exam, nothing to address the legal services gap in our state. I encourage this board to review the commission's work and see how other jurisdictions license lawyers in effective ways that protect the public without relying solely on an exam. While the BRC did not reach consensus on exam alternatives, the work done in the non-exam pathway subcommittee included robust discussions of a pilot program, all of which is insightful to the PLL options under consideration today. The opposition voices come from those who stand to benefit economically if the exam remains the sole method of licensure. I urge this board to be skeptical of the California Lawyers Association, whose October 11th letter misrepresented the commission's work and did not survive fact-checking. I encourage this board to listen to the public comment received at the November 3rd commission meeting. In conclusion, I would just like to add that the proposed pilot program would provide data and help inform the Supreme Court and Board of Trustees as they review the Blue Ribbon recommendations planned for early next year. And more importantly, it is the right thing to do for the PLL attorneys who have demonstrated repetitively their competence and preparation and readiness to prepare and practice for law. Thank you.
Thank you, Ms. Bashin. Eric Abramian, once your microphone is activated, you've got 3 minutes. Welcome.
Good afternoon. My name is Eric Abramian, and I'm a provisionally licensed California attorney. I currently practice as an associate in the Civil Litigation Defense Department at Knapp Peterson and Clark in Glendale, California. After taking the California bar exam my first 3 times and learning I was unsuccessful, I decided to enroll in the State Bar's Provisional License Program and was admitted as a PLL in December 2021. I enrolled in this program because it was the only way to practice what I spent the last 4 years learning in law school. Since the program's inception, I felt it was incomplete and needed development. I had trouble understanding whether the State Bar had so much confidence in all PLLs that it expected every single one of us to pass before the expiration of the program, or whether its purpose was to show PLLs how productive and rewarding it could be to practice, only to then revoke our licenses and leave us with no choice but to pass the bar exam or change careers if we wish to remain in the state. I, like all PLLs, have proven my competence to practice law in California by working as an associate and being given the same responsibilities as attorneys who have passed the bar exam. I've represented clients at hearings, taken and defended depositions, written and filed motions with the court, propounded and responded to discovery, conducted research on complex litigation matters, and counseled clients with deposition and trial preparation. The Provisional License Program is incomplete without a pathway to full licensure. PLLs have invested too much of their time into practice and been failed by ridiculously low passage rates for repeaters of the bar exam too many times to move forward by any other means than a pathway to full licensure. An extension of the Provisional License Program is necessary, but not enough. Passage rates among repeater examinees as low as 17% in July clearly demonstrate a pathway via the bar exam may never be achievable for PLLs regardless of how much we study and how many times we sit for the exam. The Provisional License Program is the State Bar's opportunity to lead rather than follow, and to move towards creating a system that ensures greater certainty and competence through real practice. Thank you.
Thank you, Mr. Abramian. Next is Christian Ramos. Christian, welcome. You'll have 3 minutes once your microphone is activated.
Good afternoon. My name is Christian Ramos, and I would like to speak on today's agenda item regarding the recommendations to the Supreme Court regarding the pending sunset of the Provisionally Licensure Program. I have been a provisionally licensed lawyer since November of 2020. I am speaking today to urge you to not only extend the program, but create a pathway to licensure, as I believe those of us that are provisionally licensed lawyers have had nearly 2 years of experience in which we have demonstrated our competency to practice law. I may not be a good test taker, but I am a good advocate. I have never received a complaint from a client, and my employer believes in me, as demonstrated by my continued employment. I work for a nonprofit where I help seniors with public benefits issues, obtain limited conservatorships over their adult children, and obtain restraining orders to help them keep safe. A specific point where my competency in practicing law stands out to me, in which my language, I drafted language for a carve-out in a restraining order, was used as an example for other practicing attorneys as a reference for a judge. They referred them to our organization to get help on how to draft those carve-outs. Based on the statistics shared in the agenda item memo, it is clear that PLLs are valuable to the bar. We are good at what we do and can be excellent attorneys. To my knowledge, the bar does not survey or evaluate first-year attorneys that pass the bar to obtain similar statistics. This program is an opportunity for candidates like myself to enter the bar and ensures the quality of the candidate because our requirements are greater than passing one's test. I strongly urge you to adopt option 3. Thank you for your time.
Thank you, Mr. Ramos. Next is Mariel Casano. Ms. Casano will have 3 minutes when your microphone is activated. Good afternoon.
Good afternoon. My name is Mariel Casano, and I am a supervising attorney at Legal Assistance for Seniors. We are a nonprofit in Oakland, California, and we provide free legal services to Alameda County residents. I'm speaking today regarding Agenda Item 701 on the Provisional Licensure Program. This program gave us the opportunity to hire a candidate who added to the diversity of our staff and who had been with our agency since he was a rising third-year law student. Our PLL is an excellent advocate and our clients love him. I have had several colleagues in the past that managed to pass the bar that were not good advocates, and our PLL is a good advocate. He is an essential member of our legal team. During his time as a PLL, he has worked over 2,500 hours under the direct supervision of attorneys like myself who have over 16 to 33 years of experience. If he was able to enroll in the Pathway to Licensure program, he would have met and exceeded the qualifications many times over. At Legal Assistance for Seniors, we support option 3 of extending the original PLP for remaining participants to allow development of a pilot supervised practice pathway to licensure. We believe this option will add diversity to the bar because it allows candidates who cannot afford to take time off of their jobs and pay for repeat bar preparation and examinations an alternate, equitable pathway to licensure. We strongly urge the Board of Trustees to approve that recommendation, or in the alternative, we support extending the Provisional Licensure Program. Thank you for your time.
Thank you, Ms. Casano. Next is Lee Farron. Welcome, good afternoon.
Good afternoon. Thank you so much. My name is Lee Farron, and I'm an attorney with One Justice, a legal nonprofit organization in California working to strengthen the legal service sector's expertise and capacity to advance justice and equity. We comment today to share our support for continuation of the provisionally licensed lawyer program. We support the Board of Trustees recommending option 1 to the Supreme Court, as well as either options 2 or 3. The PLL program has allowed a one justice attorney to become licensed and has increased the capacity of legal services organizations throughout California, allowing them to help more low-income individuals at a time when there is an increase in demand for services. We believe option 2 is the most straightforward. Option 5 is as well. We wouldn't object to it, but we prefer option 2. We think that option 4, the alternative licensure status, is not a sound recommendation for the PLL program. We believe that PLL should be able to achieve full licensure with whatever program is proposed, and we do not believe it is in the best interest to manage a new licensure scheme at this time. If option 3, the pilot project for the remaining for the provisionally licensed lawyers, is chosen, we would encourage the state bar, pursuant to the legislature's suggestion, to seek feedback from and collaborate with legal services organizations, particularly to the extent that this program could be viewed as a small piece in the effort to impact the justice gap. Thank you so much.
Thank you, Ms. Farron. Next is Betty Williams. Good afternoon, Ms. Williams. You've got 3 minutes once your mic is activated.
Hi, good afternoon, and thank you to all of the trustees. I am calling on behalf of CLA, and I know you have received our many letters, and an additional letter was submitted yesterday summarizing prior correspondence, but I'm just making the comment that CLA does not favor the non-exam pathway, regardless of whether it's provided, for provisional licensees or others. And I will see the rest of my time.
Thank you. Tom Drohan. Mr. Drohan, welcome. Good afternoon.
Good afternoon, and thank you. I'm Tom Drohan. I'm with Legal Assistance to the Elderly in San Francisco, where we provide free legal services to San Francisco seniors and adults with disabilities. And I'm here to speak on behalf of our agency and our provisionally licensed lawyer, Jessica Juarez, in support of extending the program, specifically option 3, as outlined in the summary. Ms. Juarez is an excellent example of why this program should be extended. She has overcome a number of structural barriers to become a provisionally licensed lawyer. She is a single mom. She comes from a low income, low opportunity background. English is her second language, and she's the first in her family to attend college, much less graduate school. She's been a provisionally licensed lawyer here since January 2021, and she's been an incredible asset for our agency. She has drafted discovery, conducted depositions, drafted and argued motions in court, and has even argued and won an appeal at the First District Court of Appeal. She's been a fierce advocate for tenants, seniors who are being evicted in San Francisco. At this point, we are told that there are 189 housing attorney positions open across the state of California in other nonprofits. To lose an advocate, a bilingual Spanish-speaking advocate like Ms. Juarez, would be very detrimental to our agency. We spent over 1.5 years training her up to be an excellent attorney, and she is one in all but name. When we have grants from other agencies, we have deliverables, and Ms. Juarez is an important part of us meeting our goal with that. I would also like to echo the earlier speaker who talked about the bar rewarding test takers and not necessarily guaranteeing quality legal representation. In short, we ask you to continue this program to allow proven, qualified candidates become attorneys. Thank you very much.
Thank you, Mr. Drohan. Next is Sebastian Bendek. Mr. Bendek, you will have 3 minutes once your microphone is activated. Welcome.
Thank you, Mr. Duran. Good afternoon, everyone. I wanted to specifically address number 701 on the agenda. First, I would like to thank the State Bar sincerely for supporting provisionally licensed lawyers throughout this time of national emergency, and for instituting this program as a whole. The State Bar, this came at the great moment of disaster. I'm thankful. I'm sincerely thankful to have been able to have practiced as an attorney in the state of California on a temporary basis as is. But secondly, I would like to propose an addendum to option number 3 in 701. including the idea of a Chief Justice Earl Warren apprenticeship program as a counterpart to the New Hampshire apprenticeship program. As an honor to the man who authored Brown v. Board of Education, which broke the back of racial segregation and stands as a symbol of true equity and that great things are possible via apprenticeship. He himself, the very building in which the justices sit, the name in this state, is named after a man who, none better than John Marshall, he was the greatest Chief Justice. He did not take a bar exam, but he managed to be governor of the state of California. He managed to do amazing things. And that is a symbol of what the provisionally licensed lawyers have done over this period. I myself have over 3,000 hours, and I would like to address that I feel that the original PLLs have been divested from the apprenticeship pathway that was given to people who failed the bar up to 5 years ago. And I think we should be included within that group. But I believe there should be a permanent Chief Justice Earl Warren apprenticeship program in this state as a minority position that only takes maybe 10% of this, take 10% of the state's applicants a year. That is the way to make it equitable, and primarily legal aid being the main, could be one of the main servicer, as well as private firms that would be willing to take on apprentices of the law. But we are a group of 100. We are a group of 170 individuals still left, and the funding is there with LSFN. The name is there. I just feel that to have been barred for 2 years and be disbarred before we even got fully barred and sworn in, after practicing every day at Stanley Mosque courthouse, it's throwing the baby out with the bathwater. And I sincerely request the Chief Justice, thank you for listening to me. Thank you.
Thank you for your comments, Mr. Bendeck. I will sort of just editorialize a little bit here to say that although I appreciate you thanking the State Bar, our staff, and the Board of Trustees, really, we do very much owe a debt of gratitude to the Supreme Court, who directed the creation of this program, and to whom we will be making recommendations after our business today. So thank you for taking the time to address us. Next, we have Maylin Spencer. Ms. Spencer, once your microphone is activated, you'll have 3 minutes to address us. Good afternoon.
Good afternoon. Thank you. My name is Mylin Spencer, and I'm also going to speak about agenda item 701, in particular, in support of the pilot program described in option 3. I also am a member of the Blue Ribbon Commission on the Future of the Bar Exam. More importantly, I have practiced law since 1997, primarily in California. And even more importantly than that, I'm a clinical professor at UC Hastings, where I teach an in-house live client civil litigation clinic, as well as a large section of evidence, which is currently a double-tested subject on the California bar exam. I've been a professor since 2009. I've taught well over 1,000 students who graduated and took the California bar. In other words, I have spent a lot of time thinking about what makes a competent lawyer and what it takes to pass the California bar exam. I've had a front row seat to how the current exam does and does not screen for attorney competence, as well as how it discriminates against law students of color and first-generation law students. During my service on the Blue Ribbon Commission, I've learned a lot. It is true that the commission is closely divided on the question of whether to recommend exploration of a non-exam pathway. Based on my own professional experience, on the evidence presented to us on the commission from other jurisdictions, and for the reasons cited already by Dean Gardina and Professor Merritt, I strongly support the creation of a pilot program to explore a non-exam pathway to licensure. I'm convinced that a non-exam pathway has the potential to create a more competent and more diverse bar in California. For that reason, I strongly support creating the pilot program set out in option 3. Thank you.
Thank you, Ms. Spencer. Next is Abigail Cedra. Ms. Cedra, welcome. Good afternoon.
Hi, everyone. I'm a 2021 California Law School graduate and a licensed California attorney. I would like to speak on the future of the provisional licensed lawyers and various options you may recommend for future plans. Although I was not given a PLL option, nor were any favors given to 2021 graduates, even though nearly 50% of our law school education was affected by the global pandemic, I'm here to vocalize my full support for the option 3 pathway to licensure for our state. When I was sworn into this state bar exactly 1 year ago today, I was deemed competent enough to practice law simply because I passed an exam and met the character and fitness requirements. However, any seasoned attorney can tell you that a brand new attorney has so much to learn, and competent representation of a client cannot be measured simply by the passage of an exam or the possession of a bar card alone. In my first year of practice, I have complied with my duty of competence largely by associating and consulting with lawyers that I reasonably believe to be competent, as required under Rule 1.1c. One of the lawyers that I have associated with is my supervisor, Paul Groh, a provisionally licensed lawyer under the original PLL plan. Paul has over a decade of legal experience in our area of practice and has been practicing competently with his provisional license for nearly 2 years. I personally could not have developed my legal knowledge and my ability to counsel my clients without Paul's deft guidance and oversight. He and every other provisionally licensed lawyer are more competent to practice law than they were 2 years ago when they first got this license. There is simply no substitute for experience, as Ray Hayden pointed out to us just moments ago. Paul, along with every other provisionally licensed lawyer, has that advantage of experience that traditional bar passers like me did not have when we received our license. I saw criticism drafted by the LA Bar Association that supported the end of the PLL program out of fear of increased incompetence in our profession, but only pointed out that our profession has a competence problem with examples from already practicing attorneys, which may be true, but this competence problem that they highlighted stems from the existing structures we have for licensing attorneys and not necessarily from the PLL programs. We in California have the unique opportunity to implement more effective ways to welcome professionals into our field with assurance that they are qualified. The necessary conclusion of my thoughts is a reiteration of a support for a pathway to licensure that best supports the lawyers affected, their employers, and their clients. So again, I would just like to voice my support for option 3. Thank you.
Thank you, Ms. Cedra. Next is Patrick Quinn. Mr. Quinn, you'll have 3 minutes once you've joined us. Good afternoon, welcome.
Good afternoon, everybody. My name is Patrick Quinn. As a 2020 law school graduate, I first became aware of the provisionally licensed program during the darkest times of my life. I graduated during the pandemic, and shortly after, I developed adult epilepsy while studying diligently for the bar of June 2020. My epilepsy resulted in kidney failure, neurological issues, and a herd of other health problems. However, the provisionally licensed program was the boost of morale I needed mentally, spiritually, and financially. I became a provisionally licensed lawyer beginning December 9, 2020. Since this date, I've taken my duties to the court serious. I've taken my duties to the court, my clients, and my supervising attorney very serious. Over the course of the last 2 years, while being provisionally licensed, I've committed over 4,000 hours to this program. This program has allowed me to serve hundreds of people in the great state of California in the realm of criminal defense. I believe the experience for all provisionally licensed lawyers gained through this program have been able to display us of being minimally competent enough to earn an opportunity to become fully licensed. This program was established under exceptional circumstances, and I believe these exceptional circumstances will justify creating a pathway for us to gain full admission. I am here to also support option number 3 with one amendment. I would recommend the Board of Trustees to strike the NPRE requirement as suggested by a fellow PLL earlier. As of this week, I was going to be set to take the NPRE. However, I developed and caught influenza A, which I'm currently sick at home. So I couldn't go take the NPRE. There's many things in life like that happens. I just wanted to come on here and again, just thank everybody, and I waive the rest of my time.
Thank you, Mr. Quinn. We certainly wish you healthy recovery from the flu. That is the conclusion of the public comments section. I am showing that it is 1:21, I'd like to allow for a 15-minute quick break to use restroom and sort of gather our thoughts before we get into the meat of the meeting. So Madam Secretary, if you would just, I think we have a timer on the Zoom thing. If not, we'll see everybody back here at 1:36. Thank you. Everyone, would you? Thank you, Madam Secretary. Okay, we are reconvened. We will take up our agenda in order. Thank you again to everyone who took the time to share public comment with the board. Certainly food for thought as we proceed through our agenda today. First item is item 10, the approval of the minutes of October 24th and September 22nd and 23rd, both open session. If any member of the Board of Trustees has a question or edit to any of those minutes, let us know now, please. Don't see any. May I have a motion and a...
So moved. Greg, no.
I'll second, Jose.
Thank you. Motion by Trustee Knoll, second by Cisneros. May we have the roll, please?
Broughton,
Abstain.
Chen, absent. Cisneros,
Aye.
Dela Cruz, absent. Knoll,
Yes.
Stalag, absent. Shelby,
Abstain.
Sol,
Aye.
Stallings,
Aye.
Tony.
Aye.
4 ayes, 0 nays, 2 abstain. The motion carries.
Thank you, Madam Secretary. Thank you, trustees. Next on the agenda is the chair's report. And I alluded, I think, at our executive committee meeting that it's been only 2 months since our last regular meeting, but quite a bit has ensued in that intervening time. And so my chair's report will be a little longer than usual today. I thank you in advance for your patience and your indulgence. Many different issues have been sort of percolating and coming to the fore. I believe the trustees are all aware of the disclosures that the State Bar made on the prior disciplinary matters involving Tom Girardi. A couple of weeks ago, I sent an open letter to the public underscoring how seriously the board and I take our statutory mission to protect the public. As I said in the letter, meaningful change begins with a culture that values transparency and accountability. I think it's safe to say that in all of our interactions as a group of trustees, that's been a guiding principle to our decision-making generally, certainly with respects to these issues that are forefront in the public's mind. The open letter also discussed the reforms to the attorney discipline system that the State Bar has developed and implemented. One of those reforms noted in the letter is the development of an automated process for identifying patterns of complaints at intake. This has generated some confusion as to whether or not the Office of the Chief Trial Counsel had been looking at patterns of complaints historically in its work. If my letter gave the impression that the State Bar has just started looking at patterns of complaints, that was inadvertent and incorrect. The State Bar in the past would do manual review of complaints histories to identify patterns. Of course, this review lacked an overarching framework about how the prior complaint history should be taken into account. Now the State Bar has developed an automated process for identifying patterns of complaints at intake. The automated process uses 25 general categories for complaint allegations to make it easier for our staff and investigators to identify patterns of complaints at intake. For example, for matters involving reports of overdrafts from client trust accounts, the State Bar has implemented an additional new policy regarding consideration of prior complaints. Under that new policy, cases resulting from small bank overdrafts may not be closed without investigation if the attorney has a pending or prior, as in the last 2 years, overdraft or client trust account related complaint. Those of you who have been a part of or witnessed the work of the Ad Hoc Commission on the Discipline System will recognize that issue in particular. And that's one example of changes that are underway at the State Bar. On to other matters, I will remind you all and thank trustees Tony and Noel and Vice Chair Stallings for attending with me the November 10th public hearing on our disciplinary system, our attorney competency programs, and our admissions function. We had, I want to say, a handful of folks join us offering very thoughtful observations and provided input to Ms. Wilson and the other staff that was present, as well as the trustees who were there. So thank you, gentlemen, for your attendance, and thank you to those members of the public who took advantage of that opportunity to address the board on those general issues. That one hearing is one of two required statutorily. The next one will be on December 1st at 1 p.m. Certainly encourage every member of the board to attend and observe and listen. You'd be most welcome there. Some of you may have seen the recent coverage of the ABA Model Rule 8.3, which imposes a mandatory reporting requirement on attorneys in other states. California is the only state without some version of this ABA Model Rule. Although the question of California adoption was addressed by the last Rules Revision Commission, I believe it is time to reconsider the issue in light of where we find ourselves today vis-a-vis the discipline system and the public's trust in the profession and the state bar overall. As such, at this time, I'd like to ask the board secretary to refer this matter to COPRAC. I believe COPRAC is the body best suited to take a look at this issue anew, offer recommendations to the Board of Trustees. And so, Madam Secretary, if you would please make that note and make that referral, I'd very much appreciate it. Okay. That is it for my report. We will move on to the rest of the agenda. Does anybody have any questions on anything I've just said? Okay, thank you. That'll take us to Ms. Wilson's Executive Director's report.
Yes, and in the interest of time, I am not going to say much because I have quite a bit to say with respect to the upcoming PLL agenda items. So I will save my remarks for that, other than to note that, as you indicated, Ruben, a lot has been going on in the organization. It seems like it was now many, many months ago that we released the information about the Girardi complaints, but of course that's not even been 2 weeks. And you can see by the agendas today, not just for the full board, but for our committees as well, that we just have a robust body of work that extends well beyond the issues implicated by that release. So kudos to staff and to the board for holding and managing it all. And I look forward to getting on with this agenda.
I certainly echo that. Kudos, Ms. Wilson. Thank you to everyone for some late nights and some deep, intense work on not only the disclosure that we're talking about now, but the many issues that are on today's agenda. With that, let's move to the consent calendar. We have items 50-1 through 12 presented. Is there any member of the board who would like to pull any of those items for separate discussion before we take a motion on the consent calendar? Trustee Tony, I see your hand raised.
Thank you, Chair Duran. I would request that item 50-5, quarterly financial report, be moved to regular agenda.
Okay, we'll go ahead and pull 50-5 from the consent calendar and consider it separately. Any other member of the board who would like to pull separate consideration one of the consent items? Okay, seeing none, may I have a motion on the remainder of the consent calendar?
So moved. Noel.
Thank you, Trustee Noel.
Stallings, second.
Second by Vice Chair Stallings. Madam Secretary, may we have the roll?
Broughton,
Yes.
Chen, absent. Cisneros,
Aye.
Dela Cruz, absent. Noel,
Aye.
Saleg, absent. Shelby,
Aye.
Soel,
I'm an aye.
Stallings,
Aye.
Tony.
Aye.
7 ayes, 0 nays. The motion passes.
Thank you, Madam Secretary. Let's go ahead and take up item 50-5, the approval of the third quarter financial statements for 2022 and investment report. Mr. Tony, is there, will there be a need to ask Ms. Diaz or any other staff to join us to answer your questions?
I think, is Justin
So
prepared?
we have Justin, he's prepared to quickly go through the PowerPoint if you would like.
Yes, thank you. That's what I thought. Thanks.
Welcome, Mr. Ewert. Good to see you.
Thank you, Chair Duran. Let me share my screen really quick and I'll walk through the third quarter reports. So the third quarter reports include our financial statements and the investment report. This slide talks about our revenue. Our revenue is up over what we have budgeted. The actuals for the third quarter, year-to-date third quarter is 251.9 million. We budgeted 239.5 million. The large difference in this has to do with the Legal Services Trust Fund. The balances in the accounts, the IOLTA accounts, we budgeted balances of 3.4 billion. The actual balances are 4.2 billion. So that's a significant increase. And then also the yield, the percentage rate is much higher. As of August, it is 1.42%. And we averaged a 0.68%. So we're getting a higher return on the IOLTA accounts. The other reasons we're up, the general fund, we have some salary savings. And then we also had a settlement from legalmatch.com. The rest of the funds are relatively close to what we budgeted. And admissions has a little bit more because we had a little more applicants take the February exam than anticipated in the budget. The revenue side, you can see that we are under budget in, or this is the expense side, I apologize. We are under budget in expenses. The actuals are 220 million, whereas through the third quarter, we had budgeted 226 million. So that's about 6.7 million below. A large amount of that is due to the Client Security Fund. The payments that go out through the Client Security Fund, there hasn't been enough eligible applicants, and so they haven't had the payouts that we would have anticipated in the budget. The general fund has not had as many expenses due to some salary savings, and the other funds are pretty much close to what we had budgeted. Trustee Tony pointed out that the revenue versus expenses, we are about $30 million difference, that we have $30 million at this point less revenue than we do have expenses. And that is largely due to the fact that we get all our revenue, or a majority of our revenue, in the first part of the year, whereas our expenses last throughout the year. The investment report, we invest in government bonds and corporate bonds. We are in compliance with our investment policy. Our total market value is down, and that is due to some investments maturing. We are actively looking at reinvesting that money, so this amount will change. A majority of our investments are in LAIF, the local agency interfund, that has about 74.2 million. We are starting to see better returns because of the interest rate hikes. And so the current LAIF interest rate is 1.29%, which is an increase from even a quarter ago where it was only 0.69%. And obviously a lot more since last year where it was only 0.22%. These are kind of a summary of our investment report. The top part is the government bonds and corporate bonds. The middle is the LAIF. And then we also have loans that we've taken out for the certain things that we were authorized to spend so we could get the money up front. And those loans are being invested in the Bank of New York Mellon Trust. And so as we go along, we are earning interest on those loans we've taken out. So that is a brief description of the third quarter report and investment report.
Thanks, Mr. Ewert. Questions on the presentation or the agenda item as a whole in the report? I don't see any. And we have a motion to approve the item as presented.
I move to approve this item as recommended by the Finance Committee.
Thank you, Mr. Tony.
Second. No.
Trustee Knoll provided the second. Madam Secretary, if we could have the roll.
Broughton,
Yes.
Chen, absent. Cisneros,
Aye.
Dela Cruz, absent. Noel,
Yes.
Saleg, absent. Shelby,
Aye.
Soel,
Aye.
Stallings,
Aye.
Tony.
Aye.
Thank you. 7 ayes, 0 nays, the motion carries.
Okay, thank you, everyone. I'm going to give you just a preview of some changes I'm going to make in the order of the agenda to try and accommodate schedules. We will take up first item 701 as listed on the agenda. Certainly, all of the public comment that we heard today should inform that discussion. And then immediately after that, we will take up item 704, which is the proposed amendments to Rule 9.7 regarding civility task force work. And then I think after that, we will do the MCLE item, which is 705.
Right.
Okay, with that, Ms. Wilson, Ms. Herskowitz, could we have the report for 701, please?
Sure. I'm going to turn it over to Donna. I don't see her. I'm assuming she's here.
I'm here.
Before she gets started, I just want to reiterate for the board that what you're being asked to do today is to approve a set of options to present to the Supreme Court. So Donna, with that, you want to take it away?
Certainly, and with your permission, Mr. Chair, I will share my screen.
That was me nodding.
Okay, I just want to make sure that everyone can see the PowerPoint.
Yes.
Okay, so as Leah said, this agenda item sets forth a slate of options that staff recommend the board transmit to the Supreme Court for its consideration in extending the provisional licensure programs that are operated by the State Bar. My plan today, and this may be a somewhat lengthy presentation, but to get us prepared to discuss the various options, I'd like to begin by first reminding the board about the two different provisional licensure programs, or PLPs, currently being operated. I wanted to highlight some information that's gleaned from our recent survey of the provisionally licensed lawyers, PLLs, and their supervisors, and some other data as well. And then I want us to turn to the options, what the guiding principles are, and what the options for consideration are based on those guiding principles. So with that, let me begin with a discussion of the original provisional licensure program. In mid-March 2020, as everybody knows all too well, the world turned upside down for so many of us and in so many different ways. The population of those who were just scheduled to graduate from law school or otherwise become eligible to take what would have then been the July bar exam was just one group of people who were so affected by that change. Following extensive public input and a recommendation from the Committee of Bar Examiners, in April of 2020, the board submitted recommendations to the Supreme Court for how to address the massive uncertainty that the world was facing. Later that month, the court responded and directed that the July bar exam be moved to September and that it be administered remotely. The court noted it would continue to explore other options as circumstances with the pandemic develop or change. In July 2020, the court did just that. Guided by the objectives of ensuring the fair and equal treatment of all graduates, while also ensuring the protection of consumers, the court moved the date of the bar exam from September to October and directed the State Bar to develop a temporary supervised provisional licensure program. The court recognized the potential financial impact that the postponement of the bar exam might have, the significant disruption that many 2020 law graduates faced. The court understood that the pandemic caused overcrowded living quarters for some, making it impossible to find a place to study, much less to sit for a remote bar exam. The bar named Trustee Harlan Chen to be the chair of the then to be established provisional licensed working group. and the group quickly undertook significant efforts to develop the provisional licensure program. So that was July. The board approved the program in September of 2020, and it was authorized by the court the very next month. Thus launched the original provisional licensure program, which was a program that was open to 2020 law graduates who either had already had an active positive moral character determination, or had at least submitted a complete application for moral character determination, who had already passed the National Professional Responsibility Exam, or the NPRE, or if they hadn't passed it, committed within the first 30 days of being in the program to take 4 hours of legal ethics training that the State Bar offered, and who committed to taking the rest of the 10-hour new attorney training in addition to those 4 hours of ethics within the first 12 months of their participation in the program. So here's what happened with that program. We had 912 provisionally licensed lawyers who were accepted into the program. Since then, 645 or more have become fully licensed lawyers. There are 173 remaining participants in the program who have one or more unsatisfied requirements, including passing the bar exam, which is by far sort of the largest outstanding requirement, with 168 people who have not yet passed the bar exam, achieving a positive moral character determination, or passing the NPRE. 125 of them have satisfied every requirement but for passing the bar exam. We will talk a little bit more about those 125 people as we get into the options. So what came next? Immediately upon submitting the recommendation to the board for creation of the original provisional licensure program, the provisional licensure working group got right back to work, reconvened to explore another option. After just a couple of more meetings and receiving in excess of 500 written comments on its new proposal, the working group presented and the board adopted a second provisional licensure program, one that would create a pathway to licensure without having to sit for another bar exam. This was open to those people who had scored between 1390 and 1439 on a bar exam that was administered between July 2015 and February 2020. We refer to this as the pathway PLP. Unlike the original PLP, this program had a pathway to licensure. The original PLP still required the passing of the bar exam, but was a stopgap measure, if you will, that enabled 2020 law graduates to practice and begin to earn an income. The rationale for creating this second program, this pathway PLP, was because this group of individuals was also suffering as a result of the pandemic, not being able to practice, though having come very close to passing the bar exam in prior years. Coupled with the fact that for the October 2020 bar exam and going forward, the court reduced the passing score for the bar exam to 1390. As a result, fairness argued in favor of this proposal. The board and then the court approved this program as well, and it launched in February 2021. For this particular program, because of one of the requirements needing to perform 300 hours of supervised legal practice, the court set a deadline for application to the program of May 31, 2021. So in addition to meeting all of the other requirements that the original PLP had to meet, as I said, these pathway provisionally licensed lawyers needed to perform 300 hours of supervised legal practice. They also needed to get an evaluation from their supervisor based on their observation that the provisionally licensed lawyer possesses the minimum competence of an entry-level lawyer. The program, this program, like the original one, was set to sunset on June 1st, 2022. Both had their sunset date extended just immediately prior to June 1 having arrived. They were both extended to December 31, which is why we are here before you today. taking a look at what was accomplished through the Pathway PLP, you'll see that we had 673 participants in the program. 538 were licensed through the program. We have 53 participants who remain in the program with one or more outstanding requirements. 18 have only completion of the 300 hours and receipt of the pending supervisor evaluation as their remaining requirements. 11 additional PLLs just have the pending receipt of the supervisor evaluation, or at least did as of the date that we collected this data. Some of them may have gotten that since then. So at this point, these programs have been operating for going on 2 years. And so at the end of September, at the end of this past September, the State Bar surveyed 4 different groups of individuals: current and former participants in the original program, current and former participants in the Pathway program, supervisors of both current and former participants in the original program and the Pathway program, and then finally, those individuals whose bar exam scores made them eligible for the Pathway, but who did not apply. And we're going to talk specifically about those folks in just a little bit. The demographic characteristics of the survey respondents was consistent with the demographic characteristics of the entire pool of all of the participants. And there's more information on the demographics that is included in attachment C. So here I'd like to focus on some of the perceptions of the program. As you can see, 92% of the supervisors reported that they were very satisfied or satisfied with the work of the participants. 83% found the provisionally licensed lawyers especially hardworking. 68% reported that having the provisionally licensed lawyer allowed the employer to serve more clients, the employer or the organization to serve more clients. 33% reported that having the provisionally licensed lawyer allowed the organization to serve a different group of clients than they were currently serving. 58% noted that having the PLL added diversity to their organization. 27% reported that the PLLs required more direct supervision than newly licensed lawyers, and 22% reported that they required more training than newly licensed lawyers. So not, far from a majority on those, but a statistic that's worth reporting. I do want to note at this juncture that there is a fair amount of data that's set out in the agenda item as well as in attachment C. In my presentation today, I'm only planning on touching on the highlights of that data. You might, those with eagle eyes might notice that there's some slight differences in some of the numbers that I'm presenting today than you see in the agenda item or the attachment. Because the survey closed so recently, we are still analyzing the data and have just recently identified a few errors in the data that was presented in the written materials. When we ultimately present whatever the board directs us to present to the Supreme Court, we will make certain to clean up any of those data issues in any of the materials that get provided.
Thank you. I'm sorry, Donna. Thank you for noting that. I apologize for jumping in, but let me just ask whether you are open to questions as you're going through, or would you like us to wait until the end?
I am open to questions whenever you'd like to present them.
Thank you. I appreciate that. I do have a question on the return rate of the supervisor surveys. 34% actually seems like a good return rate to me on a standard survey. Is that your understanding as well?
It is my understanding. I do have to say that when we originally sent out the survey, we sent it out for about 10 days, and the supervisor response rate was actually only 12%. When we met to talk about the response rates for the supervisors as well as the other participants, we decided that it was worth sending it out for another week. And so after about a week of it being closed, we reopened the survey. We sent it out to everyone who had not yet responded and gave them an additional week to respond. And that increased the response rate for the supervisors from the 12% to 34%. And we were very pleased with that outcome.
Thank you.
So then moving on to the input of the from the provisionally licensed lawyers, we had 50% of the provisionally licensed lawyers responding. 86% reported they were extremely satisfied or satisfied with the PLP. 89% found it valuable in preparing for the practice of law. 88% said that they received helpful feedback and supervision. 91% found that reported that they were able to do interesting work. 91% also reported that they were able to provide benefits to clients. 16% overall noted that they had difficulty finding a supervisor. Interestingly, that percentage is much more pronounced among the pathway PLLs than the original program PLLs. In addition to this data that's here and in the agenda item, staff, the board, the Blue Ribbon Commission, Committee of Bar Examiners have heard over this last several months from provisionally licensed lawyers and from some of their supervisors about the value that they have added with their work, with some reporting more than 2,000 or 3,000 hours of supervised legal practice, assisting some of California's most vulnerable. The supervisors of these PLLs, and we've heard a lot from supervisors. I think most of the supervisors that we've heard from tend to be from legal services organizations, and the supervisors of these PLLs have remarked about the value that the PLL brings to their organizations, and that they've increased the ability to serve clients. Important goals. But what about public protection, right? The bar's primary mission remains public protection. So even the best intentioned program to address the uniquest of circumstances can only proceed and can only continue if we have protections in place to ensure that harm is not brought upon the public that we are designed to serve. There are, in fact, and I noted some of them before, there are protections in place as part of the continuing eligibility requirements for the program, such as passing the MPRE, not having an adverse character and fitness determination, taking basic compliance training. In addition, the rules limit access to client trust accounts to PLLs. And frankly, just the fact of being subject to supervision with the requirement that the supervisor assumes professional responsibility for any work that the PLL performs, all contribute to the public protection aspect. We also looked at the complaint rates in comparison of PLLs in comparison to newly admitted lawyers. And we found that the complaint rates, looking at the number of complaints received over the total number of program participants, were similar, but in fact with PLLs having a lower complaint rate, 0.9% over the entire program versus 1.3% per year for lawyers who are licensed 2 years or less. I'm told that the difference between those two is not statistically significant, but we thought it was an important piece of information that the PLLs are not subject to any higher rate of complaints, and in fact subject to a lower rate of complaints than the newly licensed lawyers at this point. So that's a lot of background to bring us to the key point of why we're here today. So in deciding how to turn the data into a recommended slate of options, we were guided by several policy objectives or considerations that are laid out here and on the next slide. Open-mindedness to the challenges that were faced by participants, things such as difficulty in finding a supervisor, challenges in studying for the bar exam while working as a PLL, financial experiences, financial circumstances that were experienced during the pandemic, which may have limited the ability of some PLLs to put in the sufficient hours because it would have required them to quit other employment opportunities that brought in more money to their household. So open-mindedness is one of our policy objectives. Another one, ensuring that the public protection is not negatively impacted, that the public is not harmed. The third is fairness, being fair to those people who are eligible for the pathway, but did not get notice of the availability of that pathway. We'll have a little bit more on that in just a moment. Also guiding us was the awareness that that frankly, very little has gone back to exactly the way it was before the pandemic. The quote, return to normalcy, end quote, is not or does not have to be a return to exactly the way it was before. We've learned a lot. Just think about the fact that we're conducting this meeting remotely, something that we never did before the pandemic. Think about the collaboration tools that have been adopted, the expansion of remote work. There have been a lot of advances made over the last few years, and it behooves us not to ignore them, but to take advantage of them and see how we can move them into the future. And the final policy objective or consideration that we identified was the increasing openness that we see nationally to considering how minimum competence should be determined, and the growth and feelings that a traditional bar exam may not be the only way to demonstrate that someone is minimally competent and meets the minimum competence expected of an entry-level attorney. So taking these options, taking these policy objectives, and with these considerations in mind, we developed 5 options for the board's consideration and ultimate recommendation to the Supreme Court. One of those options is identified to deals with extending and reopening the pathway provisional licensure program. So that's both extending it for certain existing participants and reopening it. And then there were 4 options that were identified to submit to the Supreme Court to select among to extend the original pathway, the original PLP. So with a recommendation that the court select among those. At a very high level, and I'll go into each of them just a little bit, as does the agenda item and attachment D. The options for board consideration, option 1 is extending the pathway and reopening it. Option 2, extending the original, pardon me, extending the original PLP to give the provisionally licensed lawyers more opportunities to pass the bar exam. Option 3, extending the original PLP, and during that extension, developing a pilot supervised practice program for that group of provisionally licensed lawyers that are remaining in the provisional licensure program. Option 4, extending the original PLP and starting in after January 1, 2025, developing a permanent alternative licensure status, which, as we're thinking of now, could maybe take one of 2 forms, which we'll talk about in a minute. And the final option, extending the original provisional licensure program to allow the remaining participants to take the bar exam, like option 2, but in this instance, changing the rules to allow them to take the attorney's exam as opposed to the full 2-day bar exam. So let's talk about these one at a time. I've highlighted in each of these slides the extent to which the identified objective meets the policy objectives that was set forward, identified some relevant statistics, and I'll talk to you a little bit about the proposals. So this proposal, option 1, is twofold. Let's start with extending the program. The proposal would extend the program for 1 year. Well, actually, I'll talk about them together. So it would extend the program for 1 year and reopen the program to new participants for 3 years. So for the new participants, it would expire December 31, 2025. This option is consistent with the policy objectives of fairness to those who do not receive notice, our open-mindedness, among other things, to the challenges that were experienced by the pathway PLPs in identifying a supervisor. You'll recall I mentioned on the prior slide that 16% of the PLLs identified as a challenge identifying a supervisor. That number is 26% for the pathway PLLs. So it's consistent, consistent with those objectives. Also, in order to support the goal of public protection, we are proposing that we would limit the extension of the program to only those participants who have received their positive moral character determination, still have an active moral character positive determination, have passed the MPRE, and have completed the 10-hour new attorney training requirements. We think that this is an important way to ensure public protection, that we don't have people who have not yet achieved a positive moral character, who have not passed the ethics exam that is offered multiple times every year. We are fully aware that there are individuals that you've heard from today, that many of us have heard from individually, who have very compelling individual circumstances for why they've been unable to meet one or more of these requirements. But at this point, staff believe that discontinuing their participation as of the anticipated sunset of this program, 12/31/2022, is appropriate in order to meet our public protection mission. I will note that these eligibility requirements, who we propose to extend the program to, are the same for all of the options. And so I am going to opt not to discuss them for each one of the options. As to the reopening of the pathway, as we noted in the agenda item, the development and the existence of these provisional licensure programs were incredibly visible to those who are actively monitoring the State Bar's website and the State Bar's social media. And we had multiple public meetings at the board level, the Provisional Licensure Working Group, Committee of Bar Examiners. We received over 600 written public comments on the proposals, not to mention oral public comments in the meeting. But logically, and to be fair, not everyone who qualified for the pathway would have been monitoring those channels. We had people who maybe last took the bar exam in July of 2015, who've moved to other states, who are not reading the legal press, much less the California legal press, and simply would not have become aware of it through the channels that we advertised it. It had been our absolute intention to send a direct communication to those individuals whose bar exam scores made them eligible for the program. But unfortunately, that did not happen. There was a miscommunication and the email was not sent. 85% of the eligible, of those who would be eligible, 85% of the survey respondents of those who would have been eligible but did not participate indicated that the reason they did not participate was that they were not aware of the program. I myself responded to about 200 emails from individuals who received the survey and expressed to me that very issue. One thing I would note with regard to this this option, for reopening the pathway, we are proposing that the application deadline for the new entrants to the program it be June 30th, 2023. The agenda item contains a typo on that date. It actually says June 30th, 2022, which obviously is not what was intended because that date has passed. Attachment D, which also lists the options, correctly states that the intended date of the application deadline is June 30, 2023. Before I move on to option 2, this might be a good time to ask if there are questions.
Thank you, Donna. Does any member of the board have any questions on what's been presented so far? Donna, before you move on, I do want to say that I appreciate your recognition of the importance of that failure to notice and how it happened. And certainly, to the extent that I can on behalf of the organization, I offer my apologies to those people who were not notified when they could have and should have been. So thank you.
So the second option that we propose is simply extending the original provisional licensure program for 3 years, giving additional opportunities to the remaining participants to sit for the bar exam. As you can see, this option also advances some of the policy objectives and is supported by the survey findings. It's consistent with our objectives of being open-minded and understanding the challenges that are faced. 40% of those who participated in this PLP noted the challenge of studying for the bar exam while doing full-time work, and that was mentioned during the public comment period. There is support. You'll see 44% of supervisors support this option of extending the PLP to allow people additional opportunities to take the bar exam. 44% of the original participants also support this idea. And again, just to highlight, and I won't say it again, to ensure that it does not negatively impact public protection, staff are proposing the limitations on the extending the eligibility for those who have passed the MPRE, have an active positive moral character determination, and have completed the 10-hour new attorney training. Moving on to option 3. And you heard a fair amount about option 3 in your public comment today. Option 3 would extend the provisional licensure program for 3 years, but instead of requiring the 125 or so remaining participants who meet the eligibility requirements to sit for a bar exam, under this option, if selected by the Supreme Court, if the option were selected by the Supreme Court, the state bar would, while the program is, while the extension is going on, the state bar would develop during the course of the extension a pilot program for a supervised practice pathway. That program would obviously be approved, have to be approved by the board as well as the Supreme Court. With only 125 or so participants, this would be a really small pilot that would allow the state bar to gather empirical evidence to inform a future decision about whether to adopt a different way to prove competence, to prove minimum competence than the traditional all or nothing 2-day bar exam. Specifically, by allowing participants to just demonstrate minimum competence through actual practice with objective assessments, whether exams, reviews of portfolios, simulations, or other assessments. I think it was, I think it may have been Rianne Pacheco from the Legal Aid Association of California who so eloquently said, who so eloquently pointed out to you that that a different pathway to establish minimum competence, a supervised practice pathway, is not easier, it is different. There is growing openness to new ways to demonstrate minimum competence nationally, and understanding that the bar exam is not the end all and be all, and that there are other ways to also establish minimum competence, and that's what this proposal would take advantage. Obviously, from the public comments that you've received in writing, as well as what you heard today, this is not a non-controversial proposal. There have been questions for years, I would say, about the ability of a bar exam to identify minimum competence. There have been questions throughout the literature on the impact, in particular on diverse populations, of using the bar exam as a tool to determine minimum competence. Nationally, adopting or exploring options like this has been gaining some traction. Innovative programs like California's Provisional Licensure Program were developed during the pandemic, and there are a number of states are exploring permanent alternative solutions. So staff believe that the unique circumstance of having 125 or so remaining participants in the program presents us a great opportunity to develop a controlled and monitored pilot project to gain experience with a supervised pathway. And that's why we recommend that the board include this in the slate of options that it presents to the Supreme Court. Pardon me. Option 4 The fourth option is similar to the last one, but instead of creating a supervised practice pathway, this option would have the State Bar develop an alternative license option, which could be a permanent PLL license where the provisionally licensed lawyers would have the full responsibilities of a lawyer, but would always, under this type of license, be subject to supervision. A different kind of alternative license could be a limited scope license, where the person wouldn't be able to perform the full scope of duties of a fully licensed lawyer, but would, without supervision, potentially be permitted to provide legal services in identified areas, things that don't implicate life or liberty, areas that are less complex, where assistance from someone with legal training would be valuable. We envision that this type of license, because the scope is limited, would probably be without supervision, but of course are open to any direction that the Supreme Court would give us on that. And then finally, our fifth option. This option is very similar to option number 2, which extended the provisional licensure pathway for 3 years, allowing the participants more time to take and pass the bar exam. The difference here is that this option would allow the remaining participants, after completion of a to be decided number of hours, it would allow them to sit for the 1-day attorney's exam instead of the 2-day full bar exam. In other words, they would take the California specific exam, but not the multi-state bar exam, the MBE, the multiple 200 question multiple choice test, that test what some describe as the law of nowhere and what others describe as the law of everywhere. To help inform the board in its consideration of this item, of this agenda item, as we noted, let me try that again. Moving on from option 5, to help inform the board in its consideration of what options to present to the Supreme Court. As noted in the agenda item, we surveyed the members of the Committee of Bar Examiners to get their individual input, since we did not have the opportunity to review the survey findings, much less the options developed from them with the full committee. It was before the slate of options was developed, and so we presented some higher level options to the Committee of Bar Examiners members individually. Unfortunately, we only were able to receive input from 5 of the 18 sitting members of the committee. We have a couple of brand new members, and I wouldn't have expected them to feel like they were in a position to respond, most certainly. Of the 5 responses that we got, 1 member supported a permanent PLL license. The other 4 supported sunsetting the original PLP, but presented 3 different views on the pathway PLP, including sunsetting it, reopening it, but not extending it, or reopening it and extending it. So I'm not sure, because they had, I mean, obviously, and I think one of the reasons that some of the members didn't respond is they certainly would have preferred to have a discussion about it and to learn from others. And absent that opportunity, may not have felt that they were in a position to submit their individual opinion. But there, as you can see, there is not consensus. And so I'm not sure sort of the extent to which that informs the board's decision on this. But we did, I did want to sort of make sure to be comprehensive and to include these options that were considered but not recommended for the board. And that's to permit the programs to sunset, to reopen the pathway due to our failure to give notice, but sunset the program for current participants, or to permit the pathway to sunset and not reopen it. And then finally, there's just one thing I wanted to add, having heard and read the public comment for today's meeting and for other meetings. And I struggled over whether to say this, and I hope this isn't too harsh. But you'll note that we don't include among the policy objectives and considerations for what programs we should develop. We don't include entitlement. The Supreme Court and the board acted, I believe, appropriately and as quickly as possible to create these very exciting and valuable programs in a time of crisis. I'm proud of what was done here and how we supported people during the pandemic. We've identified a number of policy considerations that staff believe absolutely support continuing these programs in one of several fashions, as you've heard, as I've talked about all of these options. But I do personally bristle at comments that suggest that the PLLs are entitled to an extension, or that it's unfair for the board to provide that the extension of the program is contingent on having met certain requirements already, because how were they to know that they needed to meet that requirement? The program was set to sunset on December 31. Anyone who wanted to be in a position to continue to practice had knowledge long in advance of that deadline of what was required in order to continue their practice. If the board and the court authorize extension of the programs, and I very, very, very much hope that the board and the court do so, I personally disagree that requiring completion of some of the program requirements is unfair. Staff recommendations in this vein were intended to honor the state bar's mission of public protection. And with that, I will turn it over for questions.
Thank you, Donna. Colleagues, a lot of information certainly to digest, in addition to the extensive public comment, both written and oral today. I'll open the floor to questions first. If there's anything you need clarification on, anything else that you have a question about. I'm not seeing any hands going up. Trustee Sowell, please.
I just want to say, first of all, thanks. This was very sort of comprehensive and informative. I have two questions. My first one is, I understand we're just moving this along to the Supreme Court, or the staff recommendation is to move this along to the Supreme Court, all 5 options. My first question is, when I look at some of these options, I think to myself, some of them, they aren't all distinct in the sense of the court could mix and match in some respects on these things. And so they aren't all mutually exclusive. Is that a correct read of this?
It is. Our staff's recommendation is that, or staff's hope is that the Supreme Court would adopt option 1, which is the only option that deals with the pathway PLP, and then would select among one of the remaining 4 options for the original provisional licensure program, right? Because they are gradations of the same option, right? So it's extend it, allow them to take the bar exam, or extend it but allow them to take the attorney's exam, extend it but create for the people who are continuing a supervised practice program or an alternative licensure. So they are sort of different pieces of an option that all builds on the premise of extend it for the roughly 125 people remaining in the program. If you go with the staff thought process on limiting the extension to those people who, for whom the only requirement remaining is having to still pass the bar exam.
So my second question is, thank you for that. My second question is, if I project out on those options, I think 2 through 5, I think it is, and you look at option maybe 3 and option 4, those potentially could be a cost. And I know that there are, we allude to that in the staff report, but they're unknown. And is that something that we would potentially, if one of those is chosen, have to absorb? Or is that something that we would seek some additional relief from the resources from the legislature? in order to be able to implement them?
So currently our admissions, all of our admissions processes are funded by admissions fees. As you have heard in some past meetings with the Finance Committee and the board, and we'll be hearing in future meetings, the admissions budget is upside down. And so we can't continue to support all of the programs that we do with fees at the current level that they're at. Whether this is something that we would be able to go outside of those fees and ask for state general fund money for is a question that I don't have an answer to at this point. But certainly, I think that we think that with a small program, the cost of the pilot programs in option 3 and 4 would not be so overwhelming that we would not be able to absorb them because they are small pilot programs. If we were to then extend them, right, that's where you're talking about additional costs that would require the ability for us to be able to continue to be able to self-fund these programs or to find money elsewhere. Without it, there would be significant challenges.
I just want to offer a couple of thoughts. I think you meant expand, not necessarily extend the programs, but I would say that the fees that are being assessed to this population are quite low in terms of for the moral character fee. I'm not even sure. I should remember it from the agenda item, but an annual licensing fee. So I think that those things would have to be revisited as well. I also believe we have had expressed to us offline some support from the philanthropic space for some of many of the one-time costs associated in particular with option 3. So I feel like what we would probably not do is go to the legislature and look for additional funding. But there are a couple of different areas that we would need to explore to make these very small. Remember, we're talking about less than 200 people here.
Very good.
Make it happen.
Thank you.
Trustee Tony, yep.
Yes, I'm going to hold off my comments, but I do have a question. I understand this is not the first time that the trustees are making a recommendation to the Supreme Court about establishing or extending the program. How many options do we generally present to the Supreme Court when we have done so in the past?
I think it varies, and we've done this in other circumstances. When we were we presented options to the Supreme Court back in 2017 about reducing the cut score, and there were 3 options that were presented at that time in terms of whether of keeping the cut score at the same level, reducing it to 1414, I think, reducing it to 1390. When we presented, when we originally recommended the original provisional licensure program and the pathway provisional licensure program, we just presented a rule of court. Those developed out of a working group that included Supreme Court liaisons that were in frequent communication with us and the Supreme Court as the rules of court were being developed. When the letter was sent by Ms. Wilson to the Supreme Court in May of 2022, recommending an extension from June 1st, 2022 to December 31st, there were 4 options presented, 2 relating to each of the programs.
Thank you for the question and the response. Okay, if there are no further questions, let's open the floor to debate. I think the board knows and understands hopefully all the options that are in front of us for recommendation to the court. Does someone want to start with a recommendation of choosing one so that we can focus our discussion on that or those if it's more than one? Trustee Knoll, please.
Thank you. is it true that the overwhelming or good majority of people that are making recommendations so far to us have recommended option 3? Is that the?
That's generated the most public comment. And I don't know, Chair Duran, if your intention is to narrow down the options, because our staff recommendation is to present a slew of options.
Well,
I don't know that it is appropriate to try to narrow it down for the Supreme Court and letting them look at the 4 options, and then maybe they get back with questions or something if we have a dialogue with them. That would make a lot of sense, I think. I have to say, this is the most interesting testimony I've heard. I know I'm new. There's probably many other things that are going to happen with the Board of Trustees that are going to be as exciting. But I think that if California really wants to lead, really wants to be committed to diversity, really wants competent lawyers working under competent supervision, then I think we have to do our best to try and get a pathway to licensure that does not require being a good test taker, but requires you to prove your competence in another form. So, I mean, I would welcome any sort of discussion about how can we frame that. I read the letters, and I just I think the Supreme Court seems to be in favor of a program like this in certain instances, but maybe not, for all time. But I would like to see something happen that would bring a great change and great, I think, great diversity to the bar. And I may comment later. I guess that's enough for now.
Thank you, Trustee Knoll. Trustee Tony.
This is an issue that I didn't have a lot of opinion on coming in to this meeting. I read all the comments that came in writing, do appreciate all of them, and listened carefully today to the verbal comments and testimony. And I really appreciate the staff report and the recommendations. And what I think we have in front of us are, from my understanding, 2 different programs. We have the, we've got the pathway program, which I believe we have 1 recommendation that's going to the Supreme Court. That's option 1. There aren't 4 for that one. There's 1. And my understanding is that there are 4 for the original provisional license program. I just want to make sure I'm in the right place, okay?
That's right.
Okay, good, thank you. So I'm going to focus on the original provisional license, because I absolutely support, opening it up to the other program to the folks that were never notified. I think that's, goes almost without saying. So, there's a couple of interesting things I think about when I hear it. First of all, I know that minimum competence is a figure of term, but I'm not an attorney, so I don't think of it that way. I don't want attorneys who have minimum competence. I want attorneys who represent excellence in legal representation. I don't know, that's me, okay? Minimum competence really doesn't sound very good. And I, in terms of this profession, I would like us to think about what kind of programs represent the excellence in legal representation. I know when I'm hiring attorneys, that's what I'm looking for. And so I'm, when I hear people speak, when I've heard the attorneys who are provisionally licensed, when I heard the people associated with the law schools, employers of them, I really wasn't thinking about the attorneys. I was thinking about the clients they represent. That's what I was thinking about. That's who I care, in my mind. That's my priority, okay? It's not the attorneys have issues and it's difficult, and I understand, I appreciate that. But for me, even more important is the clients that they represent. And I guess I'm concerned about the clients they represent losing representation, okay? So this is, I just want to let you know why I moved to really support what Trustee Knoll said about option 3, and using that as a pilot. I cannot tell you beyond a shadow of a doubt that a supervised pathway to being licensed will result in more excellence in representation, but it's an opportunity to get some data to find out if it does. I'm not convinced that passing the bar exam represents excellence. Minimum competence, sure, but I think we want more than that. And so I would like us to put the thumb on the scales. And that means we present all of the options, all 4 options, yes, but that we put our thumb on the scale and say, but you know what? We'd really like you to prioritize number 3. Obviously, it's their decision. I know that. But I would like it so that it wasn't just all, these are all equal to us. So that's my thought I'd like to share.
Thank you, Mark. Greg, your hand went back up.
Yeah, sorry about that. Something that Trustee Tony said reminded me of something I had wanted to pass on. The statistic that keeps playing in my mind is that 15% of these folks worked in legal aid programs, while only 1% of the total bar works in legal aid programs. And the clients in legal aid programs in this time that we're living in right now are can be a very difficult group of clients to work with. Because I'll give you an example, 40% of all of the Legal Aid Society of San Diego's housing clients are seriously mentally ill. They've been clinically diagnosed. 92% of our SSI clients that we provide advocacy for, all the way to the 9th Circuit in many cases. And they have serious mental illness. We employ social workers to help those clients with things they need to get done so that the attorneys can concentrate on the job at hand for the client. And I think when you hear these folks talk about the clients they've had, the lack of complaints, and you hear their employers talk about the quality of what they bring, I don't think we can ignore that. And if it means putting your thumb on the scale, so be it.
Okay. Thank you, Trustee Knoll. colleagues, anything further? I think what we're hearing is the preferred option, at least from those who have spoken, is to present essentially all the options to the Supreme Court with a special note that option 3 should get special attention based on the public input that we've received and the concerns of the board. Is there anything that I'm missing in that characterization?
Chair Duran, I also just want to note, though, that some of the comment that we received, including from the Blue Ribbon Commission, it calls for special attention of a different sort. And I just want to be mindful of the fact that we also have asked a number of, colleagues in the legal profession to take on that role on a volunteer basis, and that we should make sure that their views are heard and evaluated as well.
I agree with that point, actually. Certainly, Ms. Wilson, maybe you and I can work together with the secretary on how to transmit the resolution to the court, either with introductory memo from the secretary or from me or from you, with those 2 comments noted specifically. Let me just double check with the rest of the trustees. Any issue with what Trustee Chen just pointed out as being part of our transmission to the court? I don't see any. As I mentioned, I agree with that point. Okay, I'm going to ask the secretary to put a resolution up on the screen, and then we'll take a look to see whether the resolution language itself has to be adjusted based on what just transpired, or whether the board is sufficient with Ms. Wilson and I and Ms. Adipatian working on how the language gets transmitted to the court. Ms. Wilson, let me just double check with you, since I know this is part of your regular duties in communicating with the court, the board's actions. Do you think that the resolution itself should include everything we've discussed, or would a letter from me or you on behalf of the board be helpful to the court as well?
I think there's an expectation that there will be a letter.
Okay.
So I think that makes sense, and we can work on it and make sure to address the points that have been made by the board members today.
Okay, and then trustees, I'm gonna take a look around the screen to make sure all of you, and this is sort of a straw poll for lack of a better word, all of you are comfortable with Ms. Wilson, Ms. Adipatian, and I working on that transmission with the assistance of General Counsel to be sure we've properly captured the discussion we've had here today. I see some nodding heads. Okay, could I get a motion on the resolution with those additional directions, please?
I'll move it, Mr. Chair. This is Arnie.
Thank you, Mr. Sowell. Is there a second?
I'll second.
We have a motion by Trustee Sowell with a second by Trustee Knoll. Again, thank you all, Donna, Leah, everyone for your hard work. Thank you, everyone who communicated with us in writing and in person today.
Yeah, really good job.
May we have a vote, please?
Broughton,
Yes.
Chen,
Yes.
noting for the record that Trustee Chen is here now. Cisneros,
Aye.
Dela Cruz, absent. No.
Yes.
Saleg, absent. Shelby,
Aye.
Soel,
I'm an aye.
Stallings,
Aye.
Tony.
Aye.
8 ayes, 0 nays. The motion carries.
Wonderful, thank you, everyone. Okay, I had mentioned before that we're going to mix up the order on the agenda a little bit. I'm going to do it once more. Thank you for indulging me. We're going to take up item 704, which is the proposed amendments to Rule 9.7 of the California Rules of Court and the Rules of Professional Conduct based on recommendations by the California Civility Task Force. This is a request to circulate for public comment. Our staff report will be offered by Erica Doherty, who looks like we have welcomed onto the panelist list. And so, Erica, Ms. Doherty, welcome. What do you got?
Thank you. Good afternoon. Trustee Stallings, do you know if Justice Curry is present? Or...
Yes, he should be on the attendee list. And if he is, could you highlight his microphone when appropriate?
Yes, we'll bring him in as a panelist.
Thank you very much for pointing that out. Justice Curry, welcome. It's good to see you.
Thank you so much for having me. I appreciate it.
Okay, let's get started.
Justice Curry, would you like to begin?
I'm happy to begin if you'd like me to. First of all, thanks for having me back, and thank you to staff and to the board for your attention to this extremely important topic of improving civility in the legal profession. I'm delighted that COPRAC and staff have spent so much time looking at the proposals of the California Civility Task Force, which, to refresh your recollection, is a joint project of the California Lawyers Association and the California Judges Association, and actually was initiated by former chair of the State Bar, Alan Steinbrecher. So we made a series of proposals to improve civility in the legal profession that would require changes to a rule of court and to the professional rules of professional conduct, which are, I think, staff will go through with you. We have reviewed the final proposal and have some comments on that, and maybe it's best for me to defer until after the staff makes their presentation. But again, thank you all so much. This is such an important topic because incivility really increases stress and dissatisfaction among lawyers. And what we have found in particular is that incivility does not get dispensed evenly throughout the profession, that women, young lawyers, lawyers of color are disproportionate recipients of uncivil conduct that is bias driven. And so I think it's right in line, right in the wheelhouse of the State Bar to make the profession more welcoming to people of color, to women, to young lawyers, and to improve the quality of representation and sort of the whole conduct of the profession by requiring civility training, the civility oath, and some rules for those who run astray. So I'll leave it at that for now, if that's all right with you, Chair Duran.
Absolutely, Justice Curry. Thank you for your introductory remarks. And I've said it before, thank you to Vice Chair Stallings, to Heather Rosing for your leadership of the task force. Thanks to the CLA and to the Judges Association for taking up the mantle of this issue in our practice, in our profession. I will tell you that in my dealings with lawyers throughout the state, with members of the legislature, this topic in particular elicits a lot of commentary, a lot of war stories, unfortunately, and certainly merits the fine attention to detail you and your colleagues have given it as represented in the staff report. So with that, Ms. Doherty, are there specific items that you would like the board to consider next?
Yes, thank you. Let me pull up my slides one moment here. Can everyone see the slide? Wonderful, thank you. So I'll dive right in because Justice Curry teed this up very nicely for everyone. But essentially, he already gave the overview of the CCTF recommendations. So I'll go ahead and dive right into the proposed revisions to California Rule of Court 9.7, and then open up the floor for any questions, and then we can address the proposed amendments to the rules of professional conduct as well. Skip right ahead here. So as brief background regarding the attorney oath, which is set forth in statute as well as in Rule of Court 9.7. Since effective May 27th, 2014, all attorneys have been required to take the attorney oath with the civility language, which is highlighted in bold there. Since it's a relatively new requirement, the majority of California licensees have not taken the civility, the attorney oath with that civility language within it. So about 48,000 have, and about 237,000 licensees, 150,000 of which are active, have not taken the civility oath as part of their attorney oath. So at the September board meeting, I presented 3 options that would have amended Rule 9.7 and required changes to require the civility pledge of all attorneys in California. Each option would have leveled the playing field, so to speak, so that everyone has taken that pledge. After the board's discussion, staff was directed to move forward with the recommendation that's set forth in option 2. And what that looks like is that by February 1st of 2024, any licensee who had not taken the oath with that civility language would be required to submit a declaration with the civility pledge language. And this would be also expanded to what are called specially admitted attorneys. And those are attorneys who are not licensed in California, but who are authorized to practice law in California pursuant to specific California rules of court. This would also require all attorneys who are practicing in California, so any licensee, regardless of whether or not they took the oath with the civility language or took the submitted the declaration with the civility language, to on an annual basis recommit to civility by affirming the civility pledge as well. So I can pause here if there's any questions regarding this 9.7. Otherwise, we can delve into the proposed amendments to the rules of professional conduct.
Let's just check around the screen. Trustees, any questions at this point? I don't see any. Please proceed.
Great. Okay. So the rules of professional conduct, CCTF recommended several amendments to the rules of professional conduct as are highlighted on the screen, but all of them were intended to clarify that civility is consistent with zealous advocacy. And the thought being that putting this into a disciplinary rule would reduce incivility and spur civility. So the Board of Trustees tasked COPRAC with looking at CCTF's proposed amendments to the rules of professional conduct. And COPRAC had some initial concerns with those proposed amendments regarding issues of interpretation, the ability to enforce them as disciplinary standards, free speech considerations, and then more specifically, they thought that some of the language within some of the rules was better suited in other areas. So as an alternative, what they recommended were essentially amendments to Rule 1.2, Comment 1, and 8.4 comment 6. They also provided a recommendation that if that was not sufficient, because those are just recommendations regarding comments as opposed to the rule language itself, they suggested that a standalone rule might be more appropriate to put it all in one area that lawyers could look to in regards to their civility obligations. So staff had recommended that 2 alternatives be released for public comment, which were COPRAC's proposed amendments to Rule 1.2 Comment 1 and 8.4 Comment 6, as well as a standalone rule as alternative options. I'm going to pause here because this may be a good moment for Justice Curry to tee up, if you would like, what he is recommending as an alternative to that.
Yeah, thank you very much. And thank you for all of the work you put into this, Ms. Doherty. Yeah, I think that the better path would, rather than offering an option to change some comments or have a standalone rule, that we put them both out as a package for public comment. I agree with COPRAC in the sense that it would be very important to have a disciplinary rule as opposed to comments, so that there could be disciplinary enforcement for incivility. Well, let me just tell you, as a justice and former Superior Court judge, there's a widespread belief among the judiciary that incivility already is covered by a disciplinary rule in the state bar. And you all may scratch your heads when judges repeatedly refer to you instances of lawyers being uncivil during litigation, thinking that you're going to enforce some disciplinary rule. Well, there really isn't one at the moment. And the whole thinking behind this is that there ought to be. So our thought is, yes, let's take the good work of COPRAC in terms of clarifying some comments and take them up on their suggestion as well, that there be a standalone rule. And we fully endorse the staff's recommended rule. It's not exactly what we might have come up with by ourselves, but having more cooks in the kitchen is always helpful, I think. So we fully support that, and we support the changes to the comments as well. I mean, I'm happy to unpack the proposed rule or let your staff do it. There are reasons why it's clear to me there are reasons why the language that's there was chosen. And I think that we'll have a lot of comment from the public with respect to the particular language of the rule. But that will be good for us to come up with the best possible rule for the people of the state of California.
Thank you, Justice Curry. I wholeheartedly agree with that last statement.
So, Chair, if you'd like, I can go through each of these things in a bit of detail, if that would be what the group would like. Otherwise, we can kind of just discuss it more broadly.
Let's start with the broad discussion, and if folks want to focus in on something, we can certainly do that. Ms. Doherty, go ahead.
Okay, apologies. So there essentially what's on the table are now two options, which would be to move forward with what was originally the staff recommendation, which is to issue as alternatives proposed amendments to 1.2 and 8.4 as was recommended by COPRAC, and then alternatively a standalone rule. If the board would like to move forward with what Justice Curry just presented, as to present them all as a comprehensive option, that is certainly something that could be done. In the written materials that Justice Curry offered, he did mention eliminating what is in 8.4.2 subparagraph B as in boy, which is now on your screen. The only staff recommendation in regards to that would be to basically put some of that language into a clarifying comment within the rule, which is comment 4. And I can show kind of what that would look like, but that gets a bit into the weeds, and I'm not sure that that is what the board would like to do at this time.
No, I agree and understand what you've just said. And just a reminder to the trustees, right? This is what we're putting out for public comment. I think we probably want to be more broad than less. And then when the public comment is returned, take up in detail some of the specific language would ultimately be recommended. My thought. Any other questions or thoughts from the trustees at this point? Okay, Ms. Doherty, please proceed again.
That's essentially all I have. So we can move along to a modified resolution, depending again upon the group's preference. I'm going to stop sharing just so I can see everyone, and I can pull up the modified resolution if you'd like.
Yes, please.
I couldn't tell, Chair Duran, if your preference was to go with the Justice Curry approach, the both instead of the either or.
Yes.
Okay.
Yeah, I think
the modified res though.
Being more inclusive when you're sending out to public comment is the better option here. But certainly open to a debate on that topic if any of the trustees have a different point of view or a more refined one.
Mr. Chair, I would also share in that approach.
As do I.
Okay, good, thank you. Looks like we will get the modified resolution up on the screen.
Yes, and so just one clarifying question, Chair Duran, would be, so in Justice Curry's written recommendation, it was to eliminate subparagraph B as we just discussed. Is that something the board would like incorporated at this time, or would you prefer that subparagraph B be included in the rule that is released for the proposal that is released for public comment, with the thought that it could be revised after the initial public comment period, possibly? Okay, I see the question. Trustees, I don't want to steer the ship. I'm the chair. I'm supposed to be a little neutral here. And I see Mr. DiFenturum has something to offer us. Thank you, sir. I was wondering when you might raise your hand. I know that you hold these rules issues near and dear to your heart. So thank you for joining us.
I do. So consistent with the comment about having a broader proposal that may be narrowed or streamlined when it returns from public comment, depending on the public comment received. If paragraph B is omitted, as recommended by Justice Curry, you will have the broader version because the language of prohibition will be only what is in paragraph A, which is shall not engage in incivility. When you include paragraph B, you have narrowing language in regard to conduct before a tribunal. And so if this, for example, returns from public comment with concerns about, say, overbreath, because sometimes incivility manifests as protected speech, then we might want to consider restoring something like paragraph B to narrow the scope of the prohibition. But if you want to go out with the most broadest rule, then I think you would delete paragraph B as recommended by Justice Curry.
And let me just sort of gut check something with you if I could, Randy.
Sure.
I would imagine the folks who have been watching this issue and this item and from whom we expect comment when we release it are aware of in the tribunal sort of narrowing of this anyway, or this additional piece of that, and will comment along those lines if they feel the need to anyway.
I would believe so. The stakeholders who have been following the issue of civility as a duty, so to speak, related to a professional obligation, a professional conduct standard, go back to sort of 1994 when we were first talking about changing the oath to begin with. And so you'll note that the oath language includes the word strive. And when we filed that rule of court the first time with the court, strive was included specifically to make clear the aspirational nature of the oath. And so there is, I think, a deep understanding by the stakeholders out there that you have to walk a fine line when you're trying to regulate civility.
And I just wanted to jump in, Chair Duran, and say, I think you're talking about lawyers. We really are going to try to seek comment by the public and by, perspective or actual clients. And I do not think they're going to understand the nuances of the distinctions of what happens before a tribunal or not. So I just wanted to say that as we really are making a lot of efforts to get true public comment. And this is one where we intend to make that kind of effort.
Thank you for that. Vice Chair Stallings' hand went up.
So my question is, if we release this for public comment, but we do not include the second comment as proposed by Justice Curry, let's say we get a substantial amount of comments, you're reproposing that second comment be put into place. Would that delay our final rollout? Would that be a substantial change to the rule that would require an additional public comment period?
Ms. Doherty, I'm going to look at you or Mr. DeFantorum for the first take on that.
I would defer to General Counsel, but yes, that would likely be something that would require an additional public comment period.
Ms. Dautian?
Wow, that was the longest I've ever had to unmute myself. Apologies for that, having two screens. Yes, I believe that if we make that kind of a change after it goes out to a public comment, we may need to put it out to public comment as well. Again.
Okay. Brandon, does that get you what you need? Justice Curry?
I think so.
Yeah, I would just say that having studied this for quite a bit, I don't think there will be any appetite for subparagraph B amongst the bar, and particularly not amongst those who are opposed to any civility rule in the first place. Conduct before a tribunal is really up to a judge, and that is the most regulated place where lawyers practice. And one of the proposals of our commission, our task force, which is not before you and is before the Judicial Council, is to improve training of judges on how to recognize incivility and how to use their courtroom control techniques to deal with it. And if we're successful at that, I think that the problem of B will not be your problem. It'll be the problem of the judiciary.
The point's well taken. Okay, I think maybe now we're ready for the resolution.
Okay, hopefully, and I can make it bigger, but hopefully you should be able to see it now.
Okay. And is this,
Oh, and let me apologize. We actually would need to, so this only addresses the rules of professional conduct. There will be another vote on, there would need to be another vote on 9.7.
okay, that makes sense. I was looking for it. All right, I'm going to assume that there are no suggested or recommended revisions to the resolutions for this first part as presented. Let me just double check. Don't see any shaken heads or any hands going up. Any further discussion on what you see in front of you? Seeing none, may I have a motion on these two resolutions? Justice Curry, did you want to add something before we take?
I just want to, I didn't hear a vote or anything. I just want to be clear that the sense of the board is to remove subsection B from the proposed rule.
I believe that's the case. Ms. Doherty, you wanted to say something, I think.
Oh, no, I would just say that that's what this resolution contemplates, is that it would be to remove subparagraph B entirely. It does include the staff. It would be to remove it entirely at this time. And then it would also require removing a related comment that specifically addresses subparagraph B.
And so that direction would go with the action, Justice Curry, and would be included in the transmission.
Thank you.
Certainly. Okay, I don't see any hands up for debate. May we have the roll?
I don't think I heard a motion in the second.
Guess that would be helpful. Sorry about that. Sorry that I missed that. Is there a motion on these resolutions?
This is Stallings. I'll move it.
Vice Chair.
I'll second.
Trustee Noel with the second. Now we'll take the vote. Thank you.
Broughton?
Yes.
Thank you. Chen?
Yes.
Cisneros?
Aye.
Dela Cruz? Absent? No.
Yes.
Stalag? Absent? Shelby?
I think Trustee Shelby's left the meeting.
Okay, thank you. Absent? Soel?
Aye.
Stallings?
Aye.
Tony?
Aye.
Thank you. 7 ayes, 0 nays, and the motion carries.
Okay, thank you. Now I expect a second resolution up here. This is related to proposed amendment to Rule 9.7. Give you a chance to digest that. Any questions or commentary on this last piece here? Don't see any. Justice Curry, I'm going to assume your hand is, that's from a vestige from your last comment.
Oh, yeah. Sorry about that.
No worries. It's all good. Okay. Is there a motion on this resolution, please?
This is Stallings. I'll make the motion.
I'll second again.
Vice Chair Stallings and Trustee Noel again with the move and the second. I don't see any debate. Could we have a vote, please?
Broughton?
Yes.
Chen?
Yes.
Cisneros?
Aye.
Dela Cruz? Absent? No.
Yes. Yes.
Stalag? Absent? Shelby? Absent? Soel?
Aye.
Stallings?
Aye.
Tony?
Aye.
7 ayes, 0 nays, the motion carried.
Great. Thank you, everyone. Thank you, Ms. Doherty, Justice Curry, Mr. DeFantorum. Appreciate your work. We'll see you again soon when this comes back from public comment. Okay, I'm going to just do a quick check-in. We've been going for almost 2 hours now. My intention was to move to item 704, which is the MCLE item. Justice Curry, I'm sorry, go ahead.
You beat me to it. MCLE, right. Thank you.
All right, good. I think we'll take that item up before we do a bio break. And looking for the staff member on that. Randy, is it you?
That would be me.
All right.
Item 705 is the request to authorize public comment circulation of amendments to state bar rules governing MCLE. With me today are two professional competence colleagues. Kathy Ongiri is professional competence's senior attorney, joined our office earlier this year, and she is leading our expanded education and training initiatives. Kathy will present the recommendation on the proposed changes to the MCLE course requirements. These are the state bar rules that govern the attorney's compliance with their MCLE obligations. Also with me today is Araya Rahimatabar. She is Professional Competences Program Manager who has lead responsibility for MCLE provider certification. Araya will present the recommendations for changes to the MCLE rules intended to enhance the administration of the program. These are the rules that govern providers of MCLE, not the attorneys and their compliance. Because professional competence has evolved from its prior focus on legal ethics and now is managing the State Bar's preventative education, training, and practice support programs, you will likely be seeing more of Kathy and Araya in the future. And with that, I'll turn the rest of this presentation over to them.
All right, thank you so much for the opportunity to speak to you today. Today, we're here to provide an overview of the proposed amendments governing MCLEs. So today, I'm going to talk to you about those overviews, discuss the new proposed MCLE course requirements and the request for public comment, propose revisions to the MCLE rules, and propose revisions to the MCLE provider rules. Finally, we'll review the resolutions for board approval. So before I get into the specific changes, I wanted to talk about what the current requirements are and show you them next to the proposed changes. So let's start with the overview of the current State Bar Rule 2.72. And what this rule does is it outlines the current MCLE requirements for licensees. So unless they're subject to exemption, licensees must complete 25 hours of MCLE credit every 36 months. And of those 25 hours, it must include 4 hours of legal ethics, 2 hours dealing with the recognition and elimination of bias, including 1 hour of implicit bias, and 1 hour of education addressing substance abuse or other mental or physical issues that impair a licensee's ability to perform legal services with competence. So we'll call that one our competency requirement. Now, based on the recommendations from the Civility Task Force and requests from other stakeholders, staff has decided to take a comprehensive review. And based on that review, we are proposing a new subparagraph C and expand the course requirements to include, you'll see on the right-hand side, the 4 hours of legal ethics still, the 2 hours of recognition of and elimination of bias, 2 hours of competency. This would include 1 hour of prevention and detection, 1 hour of technology in the practice of law, and 1 hour of civility in the legal profession. Now, this proposal would not change the 25 hours total required by any licensee, but it would add 2 additional subfields, the technology and civility requirements, and it would also expand one of the subfields, that's the competency requirement. Additionally, we are requesting a new State Bar Rule 2.84. And what this rule would do is allow licensees to receive participatory MCLE credit for coaching students, serving as an attorney scorer, and or presiding as a judge over mock trial and moot court competitions at the high school, collegiate level, and law school level. Licensees would be able to claim up to 2 hours of general credit during a compliance period, although they would not be able to receive credit for grading papers or briefs related to this activity and cannot claim preparation time. Licensees would also not be eligible to combine this with any of the required subject areas of the ones I mentioned earlier, the legal ethics, recognition and elimination of bias, competence, technology, and civility. So staff is recommending that this is consistent with our other MCLE rules that provide for credit for speaking and teaching. Participation in mock trial and moot court requires similar learning and preparation by an attorney before participating in such programs. And lastly, I just wanted to mention that recognizing that our proposal does not include an exhaustive list of potential options for MCLE expansion, we are also recommending that in addition to the proposed amendments to the state bar rules, that the public comment include general questions to assist in the further development of the program. And those questions are on page 6 and 7 and include, for example, should the state bar consider adding a requirement for education that prepares lawyers for providing legal services in the aftermath of a disaster. Lastly, in terms of these proposals, we did receive quite a bit of stakeholder support, and that information is located on pages 3 to 5 of the agenda item. So next, I'm going to turn it over to Araya to discuss the changes to the MCLE provider rules.
Thank you, Kathy. Good afternoon, members of the board. As part of the consideration of changes to the course requirements, in addition to mock trial and moot court activity for MCLE credit, staff also conducted a comprehensive review of the MCLE provider rules. The MCLE provider rules are the state bar rules that set forth the requirements for an individual or organization to offer MCLE. In doing so, staff discovered that some rules could be amended to improve efficiency, reduce duplication, and facilitate provider compliance. And I'd like to take a moment to highlight some of the proposed amendments. The proposed revisions to Rule 3.600 are designed to remove defined terms not used in subsequent rules, clarify and provide more details within existing definitions, and add definitions where necessary. The proposed revisions to Rule 3.601 provide definitions and eligibility criteria for MCLE and legal specialization MCLE activity accreditation, expand on the details associated with the existing subfields, and add detail about the proposed new subfields previously presented by Kathy. And the proposed revision to Rule 3.604 further expands on and clarifies the basis for suspension or revocation of a provider's approval. And additionally, staff proposes new Rule 3.610, which is meant to outline guidelines for legal education providers interested in offering legal specialty MCLE. And that concludes our presentation, and we'd be happy to address any questions or concerns you may have at this time.
Thank you, Ms. Remy. Thank you, Ms. Angiri. Welcome to the State Bar. It's good to see you, and I certainly appreciate both of your hard work in preparing these items for the board's consideration before we release for public comment. What is next? I see that Justice Curry is no longer in the panelists. I assume maybe he wanted to offer some input to the board on the hour of MCLE related to civility. Perhaps the hour is getting late. Any questions from any of the trustees on what you've seen so far? Trustee Tony, please.
Yeah, this is just out of curiosity. Does a attorney who is an instructor for one of the, for a certified CLE course, for one of the required courses, do they get credit for that?
Yes.
You see what I'm trying to ask? Because it seems like they have to be competent in it to train it. So I'm just curious if they get credit for it or if they still have to go to somebody else's course for one of the required ones, because I really don't know how this works.
So I'll certainly let the staff correct me if I'm wrong, but the last time I provided MCLE, which is some time ago, I got extra credit. Essentially, you get additional hours for your preparation of the course that you're teaching, to the tune of maybe 1.5 to 1. Is that correct?
It's 1-to-1, so you get double the credit.
Okay, thank you. Trustee Sewell.
You know, as folks know, I am not an attorney, but I do think I understand the reasoning behind and the need for these MCLE sort of requirements. I think my question stems from what we are trying to do as it relates to our attorney discipline system and trying to ensure the fact that folks are in in a better trained sort of position so that, you know, they can do a better job on the front end of not getting themselves into trouble from a disciplinary standpoint. And I just want to make sure that some of what we're requiring and offering aligns with that part of our mission, or is that a separate sort of track that we'll be pursuing? I can see where legal ethics and those sorts of things like that kind of comport with that, but I'm just trying to make sure that there is a kind of a direct correlation into the attorney discipline sort of training that we want to try to also ensure is taking place.
Yeah, so this would be this kind of starting to expand our preventative education. For example, the competency expansion that we're asking for, that ideally would help attorneys before they get to the stage where they would need to seek some type of treatment for substance use disorder, and those types of issues could easily result in discipline. And so I think that one does. The civility requirement, I think, definitely loops back to preventing discipline. I mean, we know that lawyers that are stressed out are more uncivil. Additionally, that civility, the recommendations for the civility really want MCLEs to focus on the link between bias. So I think that one could get at two angles there. And then the technology one is really important because, you know, as we've seen over the pandemic the last 2 years, we have to get comfortable with technology and we have to adapt to it being part of the normal legal practice.
I would just say, Arnie, some of the things that Catherine spoke about in terms of the additional questions posed in the item, they really, without sort of directly making the point, but they're getting to your point. Right now, I can be a family law practitioner. I'm not required to do MCLE in family law. I could do MCLE in whatever I want to do. I've got to do these requirements that were included in that first slide, elimination of bias, etc., but nothing related to the subject area that I am practicing in. I personally wonder if it is time for us to consider more stringent requirements. I think that would be very unpopular with our licensees. But these are the kinds of broader reforms that I think the board will need to consider, and they're touched upon in that agenda item. Last year, I believe it was last year, you also approved a 5-year plan for self-assessments. Right now, the self-assessments have primarily been viewed as voluntary, other than one that you have required with respect to client trust accounting. But you could also consider increasing mandatory self-assessment as a form of prevention and tying those directly to the types of issues that we see coming up on the discipline side. So I think there is a lot more work to do in that regard. We've got a fairly open system at this point.
Okay.
I will just also, in responding to Trustee Sewell's great comment, I will say that as a leader of a law firm and somebody who thinks a lot about these issues all the time, I'm really happy to see the technology component. I'm really happy to see more time being spent on competence issues. You know, I keep abreast of what's happening in legal malpractice news, and technology is an area that really trips people up a lot, and it can trip people up in numerous ways. The lack of cybersecurity controls. Law firms could, you know, have a lot of very valuable confidential information and are the target of cybersecurity attacks. You know, people can inadvertently, if they don't do their e-discovery functions right, release highly sensitive information when they're doing court filings or not catch privileged information. And so I think it's great that there is a new segment on that. I also want to be mindful of the fact that our strategic plan has talked a lot about prevention and doing better at education. I would like, again, to have us think about the fact that we regulate individuals, we don't regulate entities, but a lot of the controls on these issues happen at the entity level. So at the law firm level or at the organizational level. Whether you work for the government or for a nonprofit or for a private firm, a lot of these controls need to happen at the entity level. And I want us to think about what trainings we might be able to provide about sort of firm-wide or organization-wide best practices. Even if we don't regulate the entities and we regulate individuals, I think there is an opportunity to provide best practices that entities can implement. And I will give, just as an example, our firm recently has gone through an audit of how best can we support our attorneys' mental health and prevent substance abuse issues. It is no secret that in the legal profession, especially in recent years, mental health challenges and substance abuse has been a huge issue affecting lawyers. And there are some best practices that organizations can follow in making sure that they're addressing these issues as best they can, being as supportive of their lawyers as they can. And it's something that we have taken a look at as an organization. And I think that the State Bar is well positioned to provide education and training to organizations on that.
Thank you, Trustee Chen. Points well taken. Trustee Broughton.
Yes, I had initially raised my hand, sort of along the lines of what Highland said. You know, there are some new rules coming in with regard to client trust accounts, and I didn't notice anything on the NCLE that would require anyone to take any direct courses on that. Of course, it doesn't apply to everyone. Some of them will apply not to government agencies, or like Highland was talking about, trust accounts may be managed by, a firm in-house, but it is something that many of us are going to have to deal with. And I thought maybe an MCLE requirement on that somewhere amidst all of the others might be helpful for those who are managing trust accounts.
I will look to Ms. Wilson to augment the answer if I've got it wrong, but part of the rollout of the client trust account protection program does include specific education. Obviously, it's optional, not required like the MCLE, but my expectation and understanding is that we are going to promote that stuff very heavily so that we can ensure compliance with the new rules.
Yeah, Kathy's been quite involved in that, so she can speak to it, but there is a mandatory self-assessment. That component is mandatory. When you go onto your profile, if you indicate that you maintain a trust account, you will have to go through the self-assessment, and it does link to other more expansive training material. But Kathy can speak to, because they've already started launching the client trust account protection program training.
Yeah, so I can speak to that really very briefly. What we're doing for the client trust account protection program is we're going to establish a toolkit that kind of speaks to Trustee Chen's issues about entities having it. So what we're doing now is we created a whole PowerPoint and a script, and once we've tested it out a few times, we do plan to make that available for people who want to do the training on client trust accounts in-house. Additionally, as Ms. Wilson mentioned, there is a self-assessment that does require people to review the rules regarding the safekeeping of client trust funds. So that is that is kind of built in, even though it's not a mandatory CLE at this time. Yeah.
I just actually took an hour's worth of seminar yesterday on this, and the rules that registering and so forth that Leah was talking about kind of come into play on January 1. But many of the attorneys I talk to don't know that that's going to happen. So, and you might only know it if you looked at your own profile, and many attorneys don't necessarily do that. So I'm wondering if when the State Bar dues go out starting, I think in November or so, that there's some sort of flyer or something in there that alerts the attorneys that there is are these new requirements that are coming, somehow to specifically notify them.
Yes, and there'll also be an all licensee email soon, really focused on this. If you go to our State Bar website, it's in the banner right now on the homepage. So we are doing multiple modalities. There'll be a social media campaign of trying to make sure that all attorneys are aware, and then they have the opportunity to sign up for a series of webinars that are just intended to train them on how to be compliant.
Important
and
point.
We do attend. Oh, sorry, Arthur. I was just going to say, and we do intend to make the MCLE CTAP webinar available a little bit more regularly probably starting in a few, like right after Thanksgiving. So licensees will have the option to attend that, and they will be able to get at least one general credit for that.
Thank you. Any other questions or comments? I will note that Justice Curry has rejoined us. So if you have a question for him, now is the time. Or Justice Curry, if you have a comment, please let us know.
Just thank you very much to the staff for putting us into the proposal, and we're very happy with it and urge that you approve it. Thank you.
Mark Broughton, I saw your hand go up and then go down. I'm assuming you're good.
I was just having raising and lowering issues, so I hope it's down now.
It is down. Before we hear a motion, I'll just offer an observation outside of the legal profession. I think the trustees know that I serve public agencies as legal counsel, and I'm on the board of an organization called the Institute for Local Government, which covers counties and cities and special districts. And they have been offering a civility training for public officials who are dealing with very uncivil behavior at public meetings, whether city council, school board, special districts. So this is, I think, would be high time for the legal profession to jump on that bandwagon if the public comment comes out the way we think it will. So if there are no other questions or comments, I may have a motion. Is there a resolution for us to consider, please? There you have it. Give you a couple of seconds to absorb it. I know it's in your staff report, but there it is for all the world to see. May we have a motion on the resolution as presented, please?
This is Highland. I'll move it.
It's Jose, I'll second.
Thank you. Motion by Trustee Chen, second by Cisneros. May we have the vote, please?
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, absent. No. Trustee No.
Yes.
Thank you.
All right.
Stalag, absent. Shelby, absent. Soel,
Aye.
Stallings,
Aye.
Tony.
Aye.
7 ayes, 0 nays. The motion carries.
Thank you, Madam Secretary. Okay, we are coming up on 3:45 in the afternoon. Let me just give the board preview of how I see the rest of the afternoon going. I recognize that we have on our agenda a RAD agenda, essentially the board sitting as the Regulation and Discipline Committee. My intention is to go to that portion of the agenda next and then return to the miscellaneous items. Before I do that, let me just check to see whether anybody needs a quick 5-minute break, or if you want to just power through. It's Mr. Tony. Okay, I'm with you. So let's make this truly a 5-minute break. We'll see you back here at 3:50, please. Thanks.
And we are now recording.
Okay, thank you, everyone. We're back from our break, and as I started to say, we're going to move to the section of the agenda numbered section 60. To refresh folks' recollection, during my chair's report at our September 22 Board of Trustees meeting, we made a move to make the entirety of the Board of Trustees now the Regulation and Discipline Committee, given our oversight and close work with the Office of the Chief Trial Counsel. And so this will be, I expect, a regular part of every one of our agendas moving forward. Absolutely an important function of the board. So let's move on to our agenda items. Item 60-1 is the approval of the open session minutes from September 22nd of the RAD committee, which this will probably be the last time we're approving RAD committee minutes. So if you want to make history, go ahead and make the motion unless there are any additions.
I have an addition, please.
Sure, of course.
I request that after members absent, that it says members observing Mark Tony, I'd like the record to reflect that.
I don't have any objection to that. Anybody on the board? Okay, Madam Secretary, will you include that in the approved minutes? And
Yes.
then, Tony, you have another?
Yes, please. The second one is either right before a closed session or right after. I want the record to indicate that Mark Tony was asked to leave for closed session.
I certainly remember making that request, and so I have no objection.
And I honored it.
I have no objection. I have no objection to the minutes so reflecting.
Thank you.
With those two corrections, can I have a motion to approve the minutes?
I'll move to approve with those amendments.
Jose, I'll second.
We have a first and a second. Tony, followed by Cisneros. May we have a vote, please?
Broughton,
Abstain.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, absent. No,
Yes,
thank you. Saleg, absent. Shelby, Trustee Shelby, Soel,
Aye.
Stallings,
Aye.
Tony.
Aye.
6 ayes, 0 nays. The motion carries.
Thank you. Next on the agenda is a discussion regarding the report on the random audit of the Office of the Chief Trial Counsel files closed between September 1, 2022 and February 28, 2021, going backwards. The item is being presented by Chief Trial Counsel George Cardona, who we just welcome into the meeting. George, good afternoon. Good to see you.
Good to see you. Glad to be here. So this is one of our regular periodic reports on the semi-annual audits of closed cases. Under our policies and procedures, we have an outside auditor who looks at groups of cases that were closed within 6-month periods. This is another one of our catch-up audits, trying to catch up on audits that were delayed as a result of the pandemic. So this audit actually looks at cases that were closed between September 1st, 2020 and February 28th, 2021. A total of 255 files were reviewed. Those files were randomly selected from, to answer a question that Mr. Tony has posed previously, from a set of 3,545 closed files that met the criteria for the random audit. So the sample size is 255 out of 3,545 cases. Those cases were sent to the auditor for review. Those cases span both all the trial teams within OCTC, so that there's a sample of closed cases from each trial team, and also a subset of cases that were reviewed and closed by special disciplinary trial counsel. The results of the audit, we've provided you with a summary of those results that was prepared by the auditor that does not contain confidential information, and then our response. I won't go through everything. I've been asked to be brief, but I'll touch on a few things and then throw it back to you. So in particular, with each audit, there's generally a recommendation to reopen some subset of files. In this case, there was a recommendation to reopen 12, which is roughly 4.7% of the total files audited. 4.7% of the 255. Of those 12, 3 involved an attorney who was subsequently disbarred. If you discount those 3 files, which we will not be reopening because the attorney has been disbarred, then it was roughly 3.4 to 3.5% of the total files audited. Our target metric for reopening is 4.3%. So this is, the 12 is slightly above that, but not extraordinarily outside the target metric. We have reviewed the 12. We are reopening the 9 that do not involve the disbarred attorney and reviewing those. As I've indicated, for 3 of those, we have reviewed them and determined that after doing initial follow-up in accordance with what the random auditor recommended, those 3 will again be closed. We will follow up on the additional 6, and in accordance with the state auditor's recommendation, you will note in this report that we've included lines that say report on implementation with a time frame for us getting back to the board to report on follow-up implementation of the random audit of the auditor's recommendations. So we will be getting back to the board on what happens with those remaining 6 files. The second thing I wanted to touch on was some training recommendations. As is usual in these reports, there are recommendations for training on various issues that the auditor identified. In this instance, we've already followed up with a training on September 13th, 2022, which did an overview training on many of the issues identified by the auditor. And in particular, we provided a 2-hour staff training on the rule of limitations and how it should be applied and when it should be applied on October 26th, 2022. There were other issues identified for training that include policies and practices on non-trust account bank subpoenas, case processing policies relating to how to speed up investigations. We will be doing trainings on those as well as additional issues, and we'll be reporting back to the board on our implementation of those training recommendations, which I expect will occur in the early part of next year. The final thing I wanted to touch on was that there were a number of files in this audit, similar to prior audits in which the auditor noted issues relating to communications with, in particular, complainants, those people who file complaints with us. That's something else that we will be following up in terms of both training and potentially some reassessment of our policies and procedures for communications with complainants. We hope to work with that on the new public trust liaison office in terms of potentially getting some assistance in providing training to staff on, in particular, how to communicate with complainants who, for example, may have multiple complaints or may have repeated communications with us indicating their displeasure with how we're handling their matters. So those are things that I expect you can see in the future that we'll be reporting back on. With that, I will end the report and simply turn it back to you. If there are any questions, I'm happy to try and address them.
Thank you, Mr. Cardona. Any questions for the Chief Trial Counsel? I do have one about the training you just alluded to, or you just mentioned specifically, actually. How long do you anticipate that to be developed and deployed? Or how long will it take to develop and how long until you deploy it?
I'm hoping that we can develop it and deploy it within the first 2 quarters of next year. So hopefully no later than by June of next year. I'm hoping it'll be quicker, but along those lines, we're looking for an outside trainer to come in and do some training on, in particular, how to deal with complainants who pose repeated complaints about how their matters are being handled. One of our investigators has some leads on people who do that type of training, and we're trying to track that down and get that signed up.
Thank you. Any other questions on the random audit report? Mr. Tony.
Thank you. What I found really encouraging about this report is that there's been a proactive attempt and work in, there appears to have already been 2 trainings since the report from what I read, and I thought that's very encouraging. The only thing I want to point out is, and the reason I asked the question, and I had asked George ahead of time so that he would be prepared with a response, is that, we want to, there's this balance between wanting to process cases quickly to reduce the backlog, but also not wanting to prematurely close complaints that maybe should be a little bit more thorough. Because I think that's what this kind of random audit found, 9 cases that were prematurely closed. It doesn't mean they shouldn't have been closed, but maybe they were closed a little bit too early. That's what I'm getting out of it. Okay, maybe if they went down further, a few of them would have been properly closed. Okay, so that's my sense of this. But just to, my math on this says that the 9 cases out of the 255, that if you do the proportion with the 35-45, it's 126 cases. It's just, if it was proportional, we don't know that it is, but it's potentially 126 cases that could have been prematurely closed, okay? Because this is just a sample. And the point of a sample is to get a picture of, without having to audit 100%, what can we expect? So I really appreciate Georgia's commitment to additional trainings and to just increasing the attention that investigators are paying to both trying to expedite, but also to thoroughly investigate. I really appreciate it.
So thanks, and that is a balance in terms of trying to assign resources and identify those cases that the investigative resources are best assigned to.
Okay, if there are no further questions, that'll take us to item 60-3, which is a discussion regarding the Office of Chief Child OCTC performance metrics.
Could I, Chair Drew, I'm sorry to be slow to unmute myself. I also think it would be useful as we're doing more of these random audits using this new process, if we could have a look back at kind of trends identified in these random audits over time. It would be useful to know if the trainings are effective, right? If, for example, the same issues are raised again and again, it could suggest that we need to do something other than the trainings we've been doing. On the other hand, if those issues don't show up again, that could also tell us something. So I think it would be useful to know changes over time.
I will take that, and yes, we can put that together and look at the prior random audits as well. I will note that one of those, the communications with complainants and respondents, is one that has popped up previously, which is why we're trying to look at that with kind of more concern.
Great, thank you.
Thank you for that point, Trustee Chen. I'll just take the opportunity to ask Ms. Wilson to just remind us about the public trust liaison. Mr. Cardona mentioned a potential role for that person in some of what we've just discussed. At every opportunity we get to tout this new program, I think is a good one. So not to put you on the spot, Ms. Wilson, but I know that you are excited about this program.
Yeah, and so our public trust liaison is Enrique Zuniga. We have not done a formal a launch of his office or function, but we have done a soft launch, and I have sent many things his way already, including some of the follow-up that was needed on emails, Ruben, that you and I received subsequent to the Girardi release. So he is a wonderful resource for those complainants who need and deserve more discussion, explanation, someone to hear their concerns. And of course, he does have avenues available to him, including direct reporting to the board on trends and recommendations to the external auditor for cases that should be looked at again. But I wanted to say in response to Hylin's suggestion that I think this will be a function performed by our Director of Compliance, also a new function that has finally been filled. This person, Antonia Donaldson, some of you have met her, will be responsible for contracting and securing the external auditors. And I've asked her to do precisely this, kind of keep track of what's being recommended over time in order to support the discipline liaisons in particular in exercising their oversight over both OCTC and the 2201 program.
Thank you for that. Okay, if there are no other points or questions on the audit, let's move over to performance metrics. Mr. Cardona, once again.
It's all right, I'm going to share my screen with the PowerPoint and then go through some of the metrics. So can everybody see that now?
Nope.
Nope. How about now?
There it comes. There you go. Thank you.
All right. All right, so this is going to go through the metrics dashboard for the third quarter of 2022. And again, I'll try and keep this brief, but basically every quarter we get a metrics. They're available for viewing in an interactive dashboard. I believe the link was circulated to everybody on the board. This is a standing agenda item. We presented on this in September of this year, and I've tried to make this PowerPoint mirror that so you can see the same things that we looked at in September. This is the cover page, and as you can see, the items marked in red are ones that showed a negative trend from the last quarter. The ones in blue show a positive trend. So there are three in particular that show a negative trend. The caseload clearance rate, which has dropped to 88%. Our target there is 100%. Last quarter it was 93%, so it's gone down again. I'll get to why I think that is. I have another slide on that in a few slides. The median days to close has increased by 2 days from 54 to 56. We see that periodically move up and down, and that 2 days is not something that I think is outside the normal cycle of what changes there. The random audit reopens for substantive reasons. I discussed in connection with the random audit, it's 4.7%, which is slightly above our target rate of 4.3%. That included 3 cases as to which the attorney was subsequently disbarred. If you discount those 3 cases, that was actually 3.5% or 3.4%. So again, I don't think that's something that for me causes particular concern. Turning then to some of the detail, this is a tracking of our case inventory. As you'll see, our case inventory has increased over the last 4 quarters, from Q4 2021 up to Q3 2022. More recently, we have seen a significant increase in the number of complaints that are being filed, and I'll get to that in a couple of slides, which I think is what's driving that, and which I also think is what's driving the decrease in our case clearance rate. This is just a longer show of that, so you can see more of a long-term trend. This is going from Q1 2019 through Q3 of 2022, so you can see the longer-term trend in terms of inventory and inventory by case age. These are our current numbers on the numbers of complaints and reportable actions that have been coming in over the last 4 months using the ADR fiscal year, the one that we now report on in the ADR starting July 1st. So for the first 4 months of the fiscal year, July, August, September, October, we've actually received this number of complaints. If we project that out, in other words, if it remains at that rate for the balance of the year, we would see 19,000 complaints and reportable actions, which, as you can see, is significantly more than we saw in any of the 5 prior years, fiscal year 18, 19, 20, 21, or 22. We are hopeful that we will see what we have seen in prior years, which is a seasonal dip over the Thanksgiving, Christmas holidays, and then another dip somewhere in the spring that will bring this number down to be more in line with what we had before. But if we don't, this is an extraordinarily large number of complaints and reportable actions, and we may see continuing increases in our inventory and decreases in our case clearance rate. So that's just something to look out for as we move forward. This is the information on our case clearance rate. As you can see, for the current quarter, it's 88%, which is well below what our target is, which is 100% and decreased. Our case age at closure, last quarter we had a spike, which I indicated was, we believed, the result of a particular respondent who had a large number of cases that were fairly old at closure. And we can see that that's gone back down to be more in line with what is the trend that we see across time in terms of case closure. This is just a longer version of that, which similarly shows the same trends that we've seen, but over a longer period of rate. The case count passing through each phase and the duration of cases. Again, here we had seen this spike in the closure at charging, the time that cases took to closure, and I had explained that we believed that was due to one respondent who had a large number of very old cases that all kind of closed at the same time. Again, that spike has come back, and we're now back on more of the average case charging time. This is just, again, a longer term view of that kind of same trend. In terms of quality, the 3 measures that we look at in terms of quality are reopens from the complaint review unit. As you can see, we're now back below our target metric for this quarter. The random audit reopens, we were slightly above that metric for this quarter, but as you can see, that periodically moves up and down. And Walker petitions denied, we're back to our target rate for this quarter of 100% for Walker petitions denied. This is our complaining witness comment survey. Again, the higher the number here, the better, because it indicates that they would more strongly agree that they are given appropriate access and that their complaints are handled with appropriate fairness. As you can see, we're right around just below 4 on access, and we're right around just slightly above 3 in terms of fairness. Again, numbers that we would hope to drive up, particularly on the fairness side. We will never get to 5, given the nature of what we do and the unhappiness that a number of complainants have when we tell them that we are not going to proceed with their complaints. But I would like to see the fairness numbers come up, and we'll be working on seeing what we can do to try and move those numbers up. In terms of turnover, last time we had talked about the kind of spike in turnover that we saw, or the increasing turnover that we saw, particularly among our investigators in the first and second quarters of 2022. That has gone back down. And if we look at our annual turnover rate for 2021, we were kind of in line. It looks at that like that spike has come down, and now we're back more in line with what's in the state bar. We have, in fact, recently completed rounds of hiring, and our hope is that we will be essentially taking into account small amounts of turnover, essentially fully staffed as of the end of December of this year, barring some unusual uptick in turnover. So that's kind of where we are in terms of that. And I believe that that may be my last slide. So with that, I will stop sharing. Oh, sorry, there is one more. So one more slide. This is our disciplinary filings. This again is an area where we are looking at what's going on and how to see if we can bring this up, or if it should be coming up. This is the total number of our disciplinary filings, notices of disciplinary charges, stipulations to facts and discipline, criminal conviction transmittals. So you can see the criminal conviction transmittals has remained essentially the same across all these quarters. The stipulations to facts and discipline, with some variations up and down, not that far off. The notices of disciplinary charges have decreased from last quarter and from back in Q2 of 2021. We're looking at what caused that. This is consistent with the ADR report, which shows a trend of decreasing numbers of attorneys against whom we file charges, which is something obviously that we're concerned about and are looking at to see if it's we're not charging attorneys who we should be. So that is my last slide. And with that, I'll stop sharing and take any questions.
Thank you, George. Any questions from the trustees? Observations? Mr. Tony.
I have a general question, and that has to do with when and where is the right time for the board to have a discussion about the disciplinary levels that are being available. I want a place where I can complain and have a discussion about these I don't know what you call it, but it's like secret letters.
The non-public private approvals.
Yeah, that stuff. I want a place to talk about that. I've complained about this for a long time, but it never seems to be on the agenda. How do we make it so that that at least is discussed? Maybe other people won't agree with me, but I still want it discussed.
So if there's a request, we can put that on the agenda either at the January or March meetings for discussion, and I can provide an outline of what the different actions we take are, and there can be discussion of that.
I'd appreciate that. Thank you.
Certainly is a timely topic, given the disclosures we recently made on the closed Girardi cases. Okay. There are no other questions or comments on the metrics. We will move to what I believe is the last item for the RAD agenda. That is the 2201 case status update from Administrator Stacia Laguna. Ms. Laguna, welcome. Good to see you. And
hi, good afternoon.
Floor is ready.
Okay, I've been told to be brief, so I will aim for that. I've provided in my report a snapshot of our case inventory. The first, I won't go into detail on the numbers, but if you take a look when you have an opportunity, you can see that our numbers are going down for particularly our older cases. And that was a major goal for me. For those of you who I haven't presented to, because I traditionally present to RAD, I started in my role on June 1st. The second chart here shows all of our current inventory in the distribution between intake and investigation. For future board meetings, I will have a dashboard similar to that of OCTC. Oriya has been working really hard on getting those case metrics dialed in, and I've seen a few preliminary versions of what my dashboard will look like. So that'll be particularly useful for not only reporting to the board, but for my own use in case management. For those who I haven't presented to before, my role involves assigning out cases to special deputies for investigation and prosecution where appropriate, but I also maintain a caseload myself, and in general, that tends to be about 10 to 15 cases. I have a few positive things to report in terms of training, recruitment, and program improvements. In October, the State Board onboarded a temporary legal secretary for our program. She's been extremely helpful with drafting letters and subpoenas. She is a bilingual legal professional, so she helps with Spanish to English translation and also file management and data entry. And with her help in taking those items off of my plate, I can focus more on the work of the SDTCs and my own cases. I am rolling out Odyssey access to the special deputies on a rolling basis. So typically the special deputies work from a physical file. That's been the historical practice. But in an effort to increase efficiency and align ourselves more with OCTC's practices in digital file management, we're going to be moving in the direction of maintaining our cases on Odyssey. So I've prioritized Odyssey access and training for those special deputies who handle the highest volume of cases, and anybody that's new onboarding, they'll hit the ground running with Odyssey access from the get-go. The first group of SDTCs had their Odyssey training in October, and they're still getting used to the system and learning. And when I get to the point where I think that learning curve has kind of come down, then I'll offer Odyssey access and training to a second group. Our training portal, when I came on board, I identified a need for having all training materials and recorded trainings from OCTC in one place for the special deputies to access. OCTC has been really helpful in that regard, and they were able to establish a Microsoft Teams folder and securely invite each individual special deputy to have access. So their materials are protected, but the outside counsel can have access to those. And just a short report on recruitment. Since coming on board, I've selected 3 new special deputies. At the time of my report, 1 was handling a caseload, and the other 2 were onboarding. Now I have 2 that are handling a caseload, and the other will onboard after the Thanksgiving holiday. And with that, I'll turn it back to anybody that might have a question for me.
Thank you, Stacia. Any questions? Okay, appreciate your continued work on this important program.
Great, thank you. Take care.
Okay, that takes us to the end of the RAD agenda. We will go back to our regular meeting. That takes us back into the 700 series of items. We've already done item 701. That takes us to item 702, which is the request for adoption of written and verbal public comment policy for Board of Trustees and sub-entity meetings. I'm showing Vice Chair Stallings, Trustee Tony, Secretary Adipatian, and Ms. Boomer as the presenters here. I'll let you all fight over who goes first.
I just want to start things off and say that the enthusiasm by Mr. Tony and Ms. Boomer is unmatched and unparalleled, so I'm happy to hand it over to them for for them to brief you on this important topic. And I really enjoyed learning a lot about the minutia of what we're about to discuss. So you guys, all the credit and all the power to you and your enthusiasm over this subject.
Thank you, Chair Duran, Vice Chair Stallings, trustees. My name is Roberta Buber, and I'm really pleased to be presenting to you this public comment policy today. Yes, Trustee Tony and I have a deep passion for ensuring that members of the public have an opportunity, a full opportunity to address you on matters of concern to them that are on today's calendar. One of the things that this policy does is first of all, it will apply to consistently to all state bar entities, sub-entities, committees, and this will ensure a consistent practice for the state bar. This policy is based on the discussion that we had with you in July, following which Vice Chair Stallings, Trustee Tony, Secretary Arapetian, and I put together a policy, the one before you today. This policy will allow the presiding officer of any meeting to ensure that members of the public, first of all, are heard in a timely manner, but also to allows the chair, it's not too restrictive, as it will allow a chair to best order the business to be accomplished that day, so it is efficient. To that end, it does allow, pursuant to Bagley-Keene, it does allow for the limitation of the total time allocated for public comment. This allocation is based on a recommendation by Trustee Tony, and it allows then for business to be conducted at your meetings, as I know you are. You have long agendas with a lot of interest. I do want to thank Secretary Arapetian and Trustee Tony again for their deep interest in this topic. And at this point, I'm happy to answer any questions as you do have the policy before you. So I don't believe I need to go through it step by step.
Thank you, Ms. Boomer. Trustees, any questions for Ms. Boomer or Mr. Tony, Mr. Stallings, Secretary Arapetian?
If I could add a couple things. We didn't want to make this as Roberta said, we didn't want to make this too prescriptive, and it's important to give the chair some flexibility. I do want to note that one of the things that I think is at discretion of the chair is if there are a lot of people who want to speak, it may be the kind of thing where people are given one chance to speak, 1 3-minute slot. It becomes, what we want to avoid is if there's a group of 50 people who want to speak, that they think they can speak at each committee, and we have several committee meetings in a day. I don't think it's reasonable. I mean, there are things that are reasonable and not reasonable. I don't think it's reasonable for every person to speak 4 times at the beginning of each committee meeting and the beginning. So I think those are the types of things that a chair would have discretion over, say, because remember, if people want to speak on multiple things, that's why we allow written comments. That's why we read written comments. So that's one thing. I think the other thing, and this is just a discussion point, is, there are different ways to take public comment. And I think that it's okay for us to listen to public comment, but I also don't feel like we have to feel compelled to dialogue with people who provide public comment. I think it's okay for us to accept public comment and thank people. And, so anyway, Those are just thoughts. I think that the way this is written gives the chair discretion and doesn't completely tie their hands. But it does say that, you know what, up to 2 hours, we should be prepared as trustees to listen to up to 2 hours if there is the need for that. But then we have to get along with our business too. We also have an obligation to conduct business. Okay, so that it's kind of a balance. So I'm very pleased with how this ended up and the input, and I also tried to exercise flexibility with the advice that was provided.
Thank you for that, Trustee Tony. I will note for the record that I'm aware that the OGC has reviewed what's been placed on our agenda for our consideration by way of this policy, and I'm assuming I know that she's transmitted to me that the policy has been reviewed and is legally compliant. Certainly, thank you for your efforts, Ms. Daptian. And if there are no further questions or commentary or discussion or debate, I'm looking around the screen once more. I don't see any. Let's go ahead and have a motion.
All right, so Jose, I'll move the item.
Motion by Trustee Cisneros. Is there a second? I'll go ahead and second the item, if that's okay, Madam.
I was muted.
Oh, great, thank you.
And I was trying to second to take that pressure off you. I'm sorry.
Appreciate that. We'll have the second from Trustee Knoll. Madam Secretary, the vote, please.
Okay, there's a resolution, and I'll mute it. Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, absent. Knoll,
Yes.
Saleg, absent. Shelby, absent. Soel,
Aye.
Stallings,
Aye.
Tony.
Aye.
7 ayes, 0 nays. The motion carries.
Okay, thank you, everyone. Item 703 is a request for approval